Yes, please, Worship. Worship, I think to mention item number 11.
Item 11.
11. Worship, here I represent respondent number 3, election tribunal. So I'm here for some time because I have not yet received any instruction.
Okay, this I is for this interlocutory application. What is it for?
Delay at the convention.
Okay.
So, Lordship, I have instructions to appear for respondent number 2 in this case, Your Lordship.
So
I've
is
yet to
it,
file my power.
so is it complete? Service, is the service complete?
Your Lordship, Dusty service has been sent and we're waiting from the client, the service.
For whom?
Dusty from the client.
Which respondent?
Which respondent?
Respondent number 2 and 4. 2 I'll be to.
2 she's
I have
here.
instructions.
And who is for?
So for
I'm for the petitioner.
Who is for?
for
Who is responsible for?
Performer. Lordship.
Performer.
Performer.
Private respondent. Okay.
Performer.
Electronic then?
Yes, yes.
Weeks.
And Mr. Imti is for R3.
The applicant state and the and respondent numbers 2 and 3 are represented. The learned counsel for the petitioner has submitted that service on respondent number 4 is not yet complete. Next paragraph. The applicant shall, while waiting for service report on respondent number 4, the applicant is directed to take fresh steps for service of notice on respondent number 4 by registered post with AD. Steps within 2 days, the notice is made returnable on, give a date after 3 weeks. Notice returnable on so and so. The learned counsel for the applicant is at liberty to collect the postal receipt number from the registry and to submit postal track report prior to the next date of listing. Stop. Next para. In the meantime, the petitioner shall file a affidavit regarding service of notice by way of Dasti. List on so and so.
So like.
Watch, just write one more thing. In the meanwhile, the learned counsel representing respondent number 2 shall file the Vakalatnama prior to the next date of listing. Yes.
May I please, Lordship? My Lord, I beg to mention item number 27 and 28. Here I'm appearing for respondent number 17. My lord, if this matter can be listed again on 24th of September.
On
24th.
okay. All sides are there. Okay, and you are for
I'm for respondent number 17.
17. Says are represented on the prayer made by learned counsel for the respondent number 17. Matter stands adjourned today, list on 24/9/2025.
Much obliged.
Lordship, hearing item number 12. Lordship, this is an criminal appeal against conviction, Your Lordship. Lordship, paperwork has already been prepared, Your Lordship. We've received 3 weeks back, Your Lordship. After going through the materials, Lordship, it appears that I may be allowed to file additional paperwork, Your Lordship.
Why additional paperwork?
Lordship, some documents have been missed, Your Lordship, and I want to add additional ground also, Lordship. It is necessary for just and fair consideration of the case, Your Lordship.
This shows this item 21. Sorry, item 12.
12, Lordship.
But in order to get the leave to file the additional paperwork, you'll have to tell us what documents you want to bring on record.
Lordship, and also additional ground, Your Lordship.
I understand. But you see, we just interacted and my esteemed sisters has correctly said
Lordship.
that in the paper book, you can only have those documents which are there in the records of the trial court.
Yes, Your Lordship, those here.
So what has been missed out?
So they have missed out
Yes,
something.
Trial court orders, Your Lordship, yes.
Trial court orders is not required because we have the records already here. We don't need that order, those orders to be brought on record in a paper book. The LCR is there.
Okay, Lordship, but I need to add additional grounds also, Lordship.
No, then the prayer is misconceived. In a criminal appeal,
Lordship,
the court does not go by the pleadings made. And in memo appeal, you take a ground
Lordship.
that is that it's not necessary that you will have to restrain yourself to those grounds. This is a civil appeal. It's in a civil appeal where when you take the grounds under section 100 subsection 3, you are required to lay the grounds. It's not a requirement in the criminal case. In the criminal case, criminal appeals, you can only say that it's not there for 2 or 3 reasons and we look into the entire thing. Unless you tell me that I am the conception I am having is wrong.
Oh, Lordship, if that is the case, then we will.
Because in criminal appeals, we deal with the evidence,
Lordship.
not on the grounds. Correct. So no, that can't be allowed. You want to do the hearing today or some other day?
Lordship, next week then. Next week, Your Lordship.
Next week, okay. Both sides are represented. The learned counsel for the appellant has prayed for leave to file additional paperwork and to take additional grounds for the appeal. Next paragraph. In the considered opinion of the court, the hearing of a criminal appeal is not limited to the grounds urged in the memo appeal, as the evidence before the learned trial court is required to be appreciated. So therefore, the prayer is not allowed. First of, however, it is made clear that it would be permissible for the learned counsel for the appellant to rely on any material available on record to base her submissions. List in the next week.
Much obliged, Lordship.
Lordship,
I beg to mention item number 22.
Item 22.
Yes, here I am yet to the bit of session. Doing 3 weeks time.
Three weeks.
3 weeks, Lordship, because without the affidavit from the union, the matter cannot be adjudicated. This is regarding the Hindi teacher.
Your Lordship, the central government is also taking so much time to file this small affidavit. The only query that is to be clarified before this on the court is the equivalence of the Hindi courses with the secular courses BA or BSc, Your Lordship. And this is pertaining to applying for Hindi job. Now, since this on court, most of the judges of this on court is also not equipped with reading the Hindi version of
Yes, yes.
the documents. And the council, I myself is not well equipped with that, except the principle that it is to apply for Hindi job. So as far as the service rule of the Nagaland Education Department,
Equivalence, who is, which authority has?
Lord, it is the
No.
Ministry of Education, Government of
The
India.
question is that which authority has said that it is equivalent?
The equality, as far as the Nagaland School Education Department service rules is concerned, they have given preference to the secular qualification, then the Hindi qualification. My clients, the petitioners, are purely Hindi students. They have given preference in the service rules at Rule 7B, Roman 4 and 5. Preference is given to those who have taken Hindi as an elective subject and not a full-time Hindi students like the petitioners. So, my lord, in that sense, the question of pursuing Hindi course is totally thrown out of the window in Nagaland, and all those who have pursued pure Hindi courses have no future in Nagaland, my lord. That's why I have challenged the rules. And for that, the explanation is to be given by the Ministry of Education, Government of India, my lord. So that simple clarification is taking such a long time.
Because you see, this is an issue which, for the purpose of equivalence, there are many judgments of the Supreme Court as well as of our court, where it has been held that it will be the employer who will say what is their requirement.
In any case, my lord, I have understood what my lord is saying. I have also gone through some judgments, but my lord, here, what the petitioners want is, we're not trying to, just because there is an equivalence, we're not going to apply in the BA courses, BSc courses or other courses, only to apply for a Hindi job, my lord. And so, in that respect, the equivalence has already
If
been
the
declared.
government rule says no, we can
clarification is
entertain the challenge, but the response from the Union of India is not even required.
My lord,
In fact, it is for the state to decide whether Hindi is equivalent to BA or not. Hence,
in my limited understanding, my lord, I thought the case
Who is the
simple, but-
who is the authority in the central government to give you that instructions?
Department of Ministry of Education.
Yes, Ministry of Education. Earlier it was under MHRD, my lord. Now it is under the Ministry of Education.
We give you 2 weeks to get the instructions from the central government.
That's budget. 3 weeks time is that sense.
You will send an email right now and then they'll get it by 10 minutes. Nowadays, email is available in your mobile.
It's also the origin.
No, don't. You're writing letters. No, send it by mobile. 2 weeks, and we give you. Okay, well, you're asking for 3 weeks. We give you 3 weeks, but we are making it clear that if it doesn't come, then we proceed in the matter without response from the Union of India. All sides are represented. The learned CEC has submitted that he is yet to receive instructions. Next para, it is noticed that this writ petition is of the year 2022. And the Education Department of the State of the Union of India,
Ministry of Education.
Ministry of Education, Government of India is already having notice of the pendency of this writ petition. Full stop. One last opportunity of 3 weeks is granted to the authorities under the Union of India to file their affidavit in opposition, failing which the matter would be heard on the basis of materials available on record. Next paragraph, the learned CEC shall send a downloaded copy of this order to the competent authorities in the Ministry of Education, Government of India, to bring this order to their notice. Next paragraph, this one, give a fixed date after 3 weeks.
If your lordship may be pleased to release me a copy of this orders, or I will then transcript.
We will not give it to you. You take a downloaded copy and send it.
Motion, Lordship.
15th October.
May I please, your lordship. I beg to mention item number 8, lordship. Kindly grant us 3 weeks time to file a written objection to the IA,
What is this IE for?
condemnation of delay,
Huh?
condemnation of ventilation.
Continuation of delay.
There is a delay of 294 days, lordship. And
Okay.
My lord, I appear for the appellant's hearing.
Number 1, 2 weeks time is granted to the respondents to file their affidavit in opposition, failing which the matter would be heard on the basis of materials available on record.
May I please, your lordship?
Yes.
My lord, I'm appearing for the appellant's Indian Oil Corporation herein. May I
Yeah.
pray for a fixed date on 8th of October if possible, my lord? Because I have to appear from out of station on this matter.
Okay, this one 8/10/2025.
I'm obliged, my lord.
Your lordship, I may be able to mention item 6, your lordship. In this item 6, your lordship, the petitioner has filed an amended petition. To which I would like to file an affidavit. 1 week time may be granted, your lordship.
My lord,
Just a moment, is a criminal writ petition.
I'm for the petitioner. He is under illegal detention now. May I please, lordship?
Just a moment. Okay, against the amended writ petition,
My lord, may I
We'll
make a
have to
small
give-
submission?
we'll have to give us some time.
May I make a small submission? Now, even without filing affidavit, it appear on record, it is illegal detention now, because the confirmation was not issued within 3 months of the initial order. I have a judgment, Supreme Court judgment. If it is illegal detention, what
No,
is the
but
point of filing affidavit then?
In preventive detention, we need the affidavit, that is the requirement.
My lord,
Even if,
on the face of the record, detention order expired. The detention or initial detention order expired on.
not without response from the Government of India. And this is PIT and DPS.
Correct.
It's
The
only
law,
taking one week's time. We are giving it.
the law settled by the Supreme Court is, if it is illegal detention, if the confirmation cannot be issued within 3 months of the initial order, then it is illegal detention and reasonable compensation also has been
But we
paid.
can't decide that without an affidavit by the state. We
But
don't know
that-
what comes up. We don't know what comes up. And it's. Both says are represented. On the prayer made by government advocate, 1 week time is granted to file affidavit in opposition in the matter. On the next date of listing, the state respondents will also produce the necessary records Is the Union of India filed their affidavit? Yes. But why you have not filed?
I have only legal neighbors. Yes,
No, this is paid NDPS.
yes, Lordship.
You are under a solemn duty to file it. Three,
Advisory board constituted by the state,
they also have to file.
not required.
Hmm?
Advisory board constituted by the state.
They'll have to also file. Just stop. All the 4 respondents are directed to file their affidavit in opposition positively as the detention of the petitioner is being assailed in this habeas corpus petition. Next para, the learned CGC as well as the learned government advocate shall send a downloaded copy of this order to all the 4 respondents. Bring the order to the notice of the said respondents. Next para, list on next week will be 25th. No, 18th. Oh, sorry, I'm speaking the wrong calendar.
17th.
It will be 17th. List on 17/9/2025. Which shall be filed by then. You sent a downloaded copy of the order. Both of you sent a downloaded copy of this order. You know the consequences of affidavit not being filed. You know the consequences of affidavit not being filed.
No, Lordship.
And you know, today only, I had addressed the students and I was telling the students of Kohima Law College that at one point of time when we were young lawyers, the advocates in the state of Nagaland were more versed with preventive detention laws. So don't break that legacy. This is one of the best courts where we could learn about
NSA detention.
NSA detentions. So don't break that tradition.
Yes.
We have law in our hand.
Huh?
We have law in our hand. You assist them. You assist them.
Well said.
This is one of the case which can show that even our own Gauhati High Court Chief Justice has imposed reasonable compensation for illegal detention. Squarely cover my case today. Madam.
May it please your Lordship. Lordship, I beg to mention item number 2. In this
Item?
case, item number 2 of the Lordship.
Yes.
In this case, there's been a subsequent development. My detention order has been confirmed and I've received a copy this morning. If I may be allowed to place this order by way of an additional affidavit, and if this matter can be fixed for the 17th of September next week.
We'll grant your prayer, there's no issue, but I have my own reservations.
Yes, sir.
You see, I think if you are to challenge this order, you'll have to make a amendment to your writ petition also. By way of an affidavit, we can't enlarge the scope of the writ petition.
Your Lordship, in my main prayer, in the writ petition, I have challenged the basic order plus all the consequential orders that would follow, including the confirmation in my prayer.
Is there?
Yes, Your Lordship. If I-
Okay. Okay, both sides are represented. On the prayer made by the counsel for the petitioner, he is permitted to file an affidavit to bring on record the order of confirmation of the detention
Yes.
based on next 17.
I'm obliged, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item 13 to 21.
13 to 21 is a Fifth matter,
Lordship, on behalf of the council, Elika Sangda. Lordship, the council can't be able to appear in the honorable court today as she's suffering with poor health. So if your lordship may kindly list the matter after 3 weeks.
is any interim order operating?
No, my lord.
No. Just give one of the items, item 26, sorry, this will be 13.
13 to 21.
Just give one matter.
This is appeal filed by the state.
From the state. It is a type, is something. Regulations, it's really for this. Intense thing. Transition.
This is regarding regularization.
Yes, my lord. Last night, my lord, last night I was informed by the petitioner of the living council. He has a difficulty, that's why going for adjournment, my lord.
Okay, both sides are represented. On the prayer made by land counsel for the respondent, the matter stands adjourned today. This is the matter after 3 weeks as prayed for. No, you just say one more thing that the prayer made by land counsel for the respondent, that the learned counsel holding the brief is indisposed. Because the matter stands adjourned today. Rest after 3 weeks as prayed for.
Much more.
For admission, item number 1.
One to fifth also. And this morning I have filed my affidavit notification.
You filed it.
Lordship, this
You
morning.
got copy?
Yes, Lordship, I received this matter be.
Pardon me?
This matter to be taken up today.
Now we are taking it up. Make your submissions.
Yes, we have this over here.
Yes.
Yes, Lordship, the innocent petition is in regard to the habeas corpus for setting aside the review order dated 15/01/2025 in the confirmation order. Lordship, here the facts is that on 7th of 2024, based on the FR, the present detainee was arrested. Now, your Lordship, Well, the detainee was in the judicial custody. Your lordship may kindly come to page 22 and actually. Yes, lordship, well, the.
She was first arrested in GRPS case.
Yes, lordship.
What is the date of arrest?
7th of 2024, lordship.
7.
Of 2024.
When she was released on bail,
Your lordship, bail has not yet been granted, lordship.
bail not yet been granted.
Yes, actually.
Give this NDPS Act. NDPS Act. Any order of rejection of bail?
No, lordship, the bill has not yet been filed, lordship. The bill has not been filed for the district session.
No prayer for bail is filed.
Yes. No, lordship, based on the proposal by the additional Director General of Police, the detention order has been given on 15/1/2025. That is an entry page 85.
Yes.
Yes. Based on the proposal issued by the additional General of Police, the detention order has been given to the detainee lordship. That is it, page 25, and entry 3. Yes, this is the first initial detention of the lordship. Lordship, thereafter the detainee had also made a representation on 14/2/2025, which is at page 26. That is an extra first serious lordship.
She said, she must have come here. She must have Just a moment. Where is your representation? They are filed before the authorities?
Yes, Lordship. It's in page 26, Lordship. That is-
26.
Yes, Lordship. Election procedures, Lordship.
And which page is the grounds?
Your Lordship may kindly come to page
Page 7.
page 7, Lordship.
Page
7, Lordship.
7.
Yes. Page 7 of the.
No, no, not this. The
Yes.
when a preventive detention order is passed, it must be accompanied with the ground.
Yes, Lordship.
Where is that?
Yes, at page 22.
22.
Yeah.
This is the proposal.
This is a proposal.
Yes, your Lordship, on the next page, page 22.
That's a proposal.
Lordship,
This is the proposal, but along with the detention order, they'll give you the grounds.
Is it page 14 of this? Page 14 of this.
your
Right from the grounds. Script. Your representation is at page
Page 20.
26.
26, Lordship.
What is the date in which this representation was disposed of?
Lordship, representation was disposed on 17/02/2025. That is it, page 33, Lordship.
Yes, who's for the government? You are appealing for 1, 2, and 3. In this detention order or the grounds of arrest, we don't find any reference to the likelihood of being released on bail. If that be so, then it is also a ground to set aside the order. And secondly, the Union of India has taken 2 months to dispose it of. That delay is also fatal.
As far as the ground is concerned, now if we have status in our, the family come to the division of page 14.
Yes.
Page 14, and next year. This is the ground of detention which was communicated to the KU.
Yes.
If I'm allowed. This is.
Yes, yes, we have seen that grounds of arrest, page 14.
Page 14.
Yes.
It was communicated to the KU. The section 51 of the
Yes.
detention is.
Here it doesn't say that the authorities took into consideration the likelihood of being released on bail.
What it does, we have mentioned in
3.
That
If kept in large or bailed,
or bail, you are likely to commit the breach of peace and security of the state, thereby endangering the life of many innocent people. Display existence of citizens and the warrant law and order problems in the state. And moreover, Lordship, for also Lordship, it is stated that there has been a huge public outcry concerning taxi and traffic of illicit drugs in the state, which is causing problems of abuse and addiction of all age groups, especially that of the teenage school children. It is suspected that you are involved directly in intra and interstate network of smuggling and trafficking of illicit drugs, whereby luring youngsters with addiction, resulting in them becoming carriers for easy earnings to cover the cost of the consumption addiction.
oh, you see, this is you read paragraph 1, you will find that this paragraph 4 is contradictory. Paragraph 4 says that which was to be disposed of at Gauhati. So therefore, in paragraph 4, that they were involved in during the youngsters in this is not going to happen in the state of Nagaland.
Lordship is well aware of what, as far as this trafficking of all those concerns, both in all the interstate and state. The consignment was seized in the railway police station, Lordship. As Lordship is well aware. And then the quantity itself is also very huge quantity. Its amount, its weight 6.78 kilograms.
It's commercial quantity.
Commercial quantity, which is very huge.
No, but you see, likelihood of being granted bail.
Lordship, in fact, Lordship, the ground of detention, Lordship, here the ground taken by the petitioner is that she has not been communicated, Lordship, in the language that she understands, Lordship.
You have taken note of it. You say that she understands Nagamese.
Yes.
We have seen that.
Lordship, and that we have explained to her in that case.
You have taken note of that.
Lord.
You took some time to read this, and therefore you have read your affidavit in opposition. But there are 2 grounds we find that number 1, you have not taken note of the likelihood of being released on bail, And second is that the disposal of the represented by the central government took 2 months' time.
That I have.
Has charge sheet been filed? No. There's no mention anywhere that about whether a charge sheet has been filed in the meanwhile.
That will- that will-
Yes, to these submissions of the government advocate, you are appealing for?
For respondent number 4.
Respondent
Unit India. I've submitted my affidavit of opposition.
But you have not given any reason why it took you 2 months.
My lord, the ones I have mentioned in my affidavit of opposition paragraph 11 at 12 now. We are waiting for the opinion of the state advisory board.
No, Supreme
After
Court has
that-
time and again said that you are not to wait.
Oh, as per the Supreme Court order, Ankit Ashok Talan versus Junior Pinda and Archer. That is, as per the judgment order, we have to beat the opinion of the state advisory board. So that we are agreeing upon, as soon as we have received the representation of the petitioner, we have to agree upon. And after considering all those things, we are waiting for the opinions set as by the report. So it become a late my lord.
I don't know how you are reading this judgment of Ashok, this Ankit Ashok Jalan.
That one is on 4 March 2021.
You have the copy of that judgment?
No, my lord, sorry.
The criminal antecedents is not there. In your confirmation order or in your detention order, there's no statement regarding the criminal antecedents of the petitioner. Okay. Okay. Yes, what more you have to say?
Lordship, I've already stated in my grounds from page 7 to 10, Lordship. Lordship, here, my grounds is that the grounds of detention has never been communicated to the detainee and has not explained any language itself. If Lordship here, she has studied up to class 4. She can understand with Manipuri and then Nepali.
That may not be a correct statement. Have you gone through their affidavit filed by the state?
Yes, Lordship.
You've gone through it. Please see page 17 onwards. This is a report before the advisory board. Come to page 20. Bold portion, please read.
Yes. Is paragraph 3.
Bold portion, read that.
Yes, I understand Nagames as I said supermarket area Timopur Naganem. I have a house here where my entire family stays, comprising of myself and I daughter. I studied till class 5 at Timopur at a private English medium school. I divorced with my husband about 10 years ago. I heard that my husband no longer is in Nagaland and I've not heard from him or sent him after our divorce. Now, yes, Lordship,
Correct. Now, if please also come. Page 16.
Yes.
Correct. Now, for example, if you are not a resident of Nagaland
Yes.
and you are a resident of Manipur, then you'd require a inner line permit to come into the state, is it not?
Yes.
So it is only when you can show that you are a resident of the state of Nagaland that you are exempted from a requirement of inner line permit.
Yes.
You don't say anywhere in your petition that you came on the strength of inner line permit. And therefore, when this report says that you have a house in Dimapur, you have to believe it. Otherwise, you would have said that, well, I am a resident of Manipur and this is my inner line permit. So it's not there.
Yes.
And since I was not aware, I had asked my sister, and she confirmed that for Nagamis, you don't have a script except English. So there's no way that it could be translated into Nagamis and given it to you. And you accepted it. It was explained in Nagamis and given it to you. And page 17, first line, the detainee was heard in person in Nagamis and she has confirmed that she was provided with the grounds. So therefore, when she was produced before the authorities, she could converse in Nagamis.
No, Lordship, another condition is that coming to page number 9, it Roman number 5, 6 and 7, Lordship.
Page 9.
Yes, Lordship. Roman number 6 and 7, Lordship.
Yes.
I may be allowed to read now too. Roman for that the respondent 2 did not reflect in the routine detention order dated, so that the detainee is under conditional custody and is likely to be released on bail or provided with discharge from the case. More so, there's no whisper of words in the detention order that there's a subjective satisfaction or accompanying reason for passing such detention order against the detainee. Now, Lordship, at remand number 7, Lordship, that the allegation in the grounds of detention in ground number 2, 4, and 5, that the detainee, if kept at large or bail, likely to breach basic integrity of the state and likely to indulge in similar activities, if not prevented from doing so. Lordship, here the detaining authority in the next line, the detaining authority does not have any material to show that there is an imminent possibility of the detainee likely to indulge in a similar activity in future, Lordship. Lordship, I've further taken those from. Lordship, with regard to this, I would also like to place one decision which was passed in a similar situated by the Lordship before this one will go for. greater than 14 para 23. Greater than 14 para 23, 24.
Para
23, 24. Yes, worship it's 83.
Was going to be there. 22.
This one. Okay.
Okay. Okay, we close the matter then. But Mr. Please give again. I can't catch very fast. Council for the petitioner. As well as Mr. V. Chimami, Leonard. Your designation is?
Advocate.
Government advocate appearing for the state respondent numbers 1, 2, and 3. And you are Mr. Zeden Goli, Leonard CGC, appearing for the Senate for the respondent number 4. Next paragraph. The learned government advocate has submitted that he has filed an affidavit in opposition on behalf of respondent numbers 1, 2, and 3 today. Today you have filed it? No, it's not today, which has been brought on record. Stop. The arguments are concluded. Order is over. Yes, you have it, please. Just send it. Just keep it for a moment. Just give it. Just flag that document where the satisfaction has been recorded. Only that one. We want to see the materials available before the authority or recording of satisfaction in their office file regarding likelihood of being released on bail. That is the only requirement we have.
Page 14.
No, that is not clearly spelled out. The likelihood of being released on bail is not there. Because till date, that's why we asked, first question we asked the counsel for the petitioner is whether the bail was granted. He says that bail was not even applied for. Okay. The just add one more line. Before that, reserve for judgment, you say the learned government advocate has also produced the relevant file regarding the petitioner. From the establishment of?
Home Department.
For the establishment of the Home Department. So the said file is retained by the court till the rendition of the order. Judgment reserved. Order reserved.
For admission, item number 3.
My lord, yeah, I'm the respondent number 4. I have yet to receive an instruction. my lord.
Just one. Sister. Don't call the Home Department people. We'll be getting this manner of disposal of this. Mr. Zimomi. Can anybody from the Home Department, secretary or above, can give us a courtesy visit? If they come, they'll have to come in by today evening or tomorrow, because Friday I would be traveling early. So Friday we will not have time. If they could just give us a courtesy call, both us will be there. You wanted an interaction as convenient to them today or tomorrow?
Most probably from political branch will be better, I think. Yes, because they are the ones who deal with these detention matters, isn't it? Political branch, Home Department.
Yes, item 3.
My lord, I'll for number 4 and I'll give you a written instruction.
But you have to give it early because this is again PIT NDPS. When was the detention order passed?
Detention order was passed on 20/12/24. And
2024.
extension, subsequent extension order was,
20 of June.
yeah. Extension order was made again on 26/25.
That last word of use you can be modified. Normally we are not trained to hear yeah. Correct.
I'm sorry, Your Lordship.
Some modification would be welcome. Because the notice has been given to you on 3/9. You were served copies then. For the state government also no response.
This morning, whether it's in the report.
No, it's not come.
It has not come.
No, it's okay. No, leave it.
Records you have.
Leave it. System.
Next one.
Next week. You be there next week. But you'll have to file it in course of the week. We can't adjourn it more. We have a timelines in the High Court rules. We have to adhere to it. Next week we are posting. All sides are represented. Ms. Inahli, learned government advocate, submits that an affidavit in opposition by the respondent numbers 1, 2, and 3 has been filed today. Let this said affidavit be tagged with record. Next para. Mr. Zeden Guli, learned CGC, appearing for respondent number 4, submits that he has not yet received instructions. Next para. In view of the mandate of law that preventive detention cases should be heard expeditiously, the court is inclined to grant 1 week's time to the respondent number 4 to file their affidavit in opposition. Next para. The learned CGC shall send a downloaded copy of the order to the respondent number 4 to bring the order to the notice. Next para. List on next Wednesday, 17th.
For admission, item number 4.
So this will go to that item number 1.
This appeal is directed against the judgment dated 8/8/2025, passing WPC 2022 of 23. Now the
But what is wrong in the order? Because you did not challenge
yes,
the selection procedure.
no, but
Having appeared in the selection procedure, why would we entertain the writ appeal?
the contention is that the policy which has been enacted by the government, it prescribes a manner in which the selection is to be carried out. Now, the entire contention of petitioner before the learned single judge has been that this procedure has not been carried out. In fact, the division bench, the learned division bench, the earlier proceedings had directed that the recruitment for the appointment should be strictly in terms of the policy of the state. Now, the policy at clause 3A prescribes the manner in which the selection is to be carried out. Now, this has been overlooked by the learned single judge. That is my humble contention as far as is concerned.
But that was considered in paragraph 23 and 24.
Of the
23, 24, 25 of this impugn order,
yes,
22 onwards to 25 or something, I forgot.
yes, yes. But
That has been considered.
yeah, this precedent, it pertains to cases where the selection procedure has been carried out in terms of the extent rules in those cases. Now, in our case, the department, after advertising the post, ought to have referred the matter to the deputy commissioner as prescribed in clause 3A.
It shows that provision,
Yes.
shows this provision, we are not acquainted
Yes,
with that
OM is
provision.
at page 70.
That OM.
20,
78.
78.
Yes. I'm relying on 3A.
Three A.
3A, yes.
Okay, so you say that the clan-based appointment should not be made.
Yes, now what the department did was straight away they went for interview. Now, interview, this process of interview is not prescribed as far as policy is concerned. But even if an interview was supposed to be held, they ought to have referred the matter to the deputy commissioner of the district. Now, the deputy commissioner will verify and examine all the disputed facts which may exist in terms of the allegations which have been raised in these petitions. This has not been done. This has been overlooked by the single judge.
And what is the dispute?
Now, the dispute is so regarding the appointment to a grade 4 post, based on this policy where the government has prescribed that those landowners in the past who have donated their land to the government for the construction of district offices and all these buildings, they are entitled to an appointment if there is an agreement. Now, in our case, there is an agreement and we relied on this.
No, because under the policy, if I remember it correctly,
Yes.
The government has already said that any agreement of that sort would be treated as null and void. There is also judgment of this court.
Yes, yes, but that is post 2005. Ours is prior to 2005. That's
Prior to 2000. Post 2005, it's not accepted, but prior.
Okay, prior to 26/7 to be accepted.
So you're saying the 3A was not resorted to?
yes, 3A was not resorted to, and in manners like this, the Supreme Court has clearly held that violation of the selection procedure is not a ground where a court can invoke the principle of estoppel. And this procedure has also been admitted by the State India affidavit, saying that after the advertisement, they went straight away for interview. No reference was made to the Deputy Commission.
But why is there a requirement to send it to Deputy Commissioner? This
3A.
is post, the post of
Grade 4 post of animal attendant.
grade 4.
Yes.
So what is the procedure for appointment in grade 4 posts in Nagaland?
Ours will be, we are confining to this policy. Land, we call it land ownership appointment, for the appointment on the basis of land ownership. Now, the procedure prescribed is 3A, which I've just read out.
3A says no land shall be acquired free of cost, and all land shall be acquired on payment of full compensation. No further condition of employment in service, which after 26/7/2005. Correct.
In other cases prior to, now ours is prior to 2005.
Where is the advertisement?
Page 79. 80 is the. This was in pursuant to the direction passed by this court
Page number?
in an earlier proceeding.
Page number?
Page number 80.
80.
Yes.
Where is the have you annexed the copy of memorandum dated 16/8,
Yes,
2018?
I just referred to that, Your Worship. Page 78.
78. Okay. But just tell me, this documents at lecture 1 of the writ petition, which is at page 47 onwards. This is your documents?
Yes, my documents. These are the documents based on which the 11 landowners, including the petitioners, they donated the land. And
No, this can't be a donation.
at page 57, by copies at page 58.
No, you see, we can't read the name at page 47.
Yes, Lordship, this was
Correct.
how it was filed in the petition. I can.
No, it's okay, it's okay. That's not material. What I can't read is not material. The contents is material. You see, Sri so-and-so of so-and-so, on my own behalf, hereby witnesses that I have on behalf of received from the government a sum of rupees 600 so-and-so for so-and-so acres of land at the rate of rupees 1,500 per acre. Now, this can't be this can't be a gift. You received in, you are receiving money.
Lordship may also take a note that, take a look at page 58.
Page
58.
58.
That's the type copy. The original is on page 57. Now, this was the condition on which the landowners parted their land. Of course, there was some compensation being paid, but this was the condition. And based on this,
You will find it difficult to convince me. You see, the reason is please tell me, I'll repeat it if I'm not very clear to you. You see, once you have a deed of release, then the terms of that release deed will prevail. This agreement at page 58 correct. You see, page 47.
Yes.
This referred to some day of 1973, right?
Yes.
It's 73.
70.
74.
74.
74.
Huh? 74.
74, I think.
75, Lordship.
Huh?
At the bottom, signed by the circle officer, it's dated 75.
No, this is countersigned.
The execution date.
Okay, 10th so and so 75. Correct.
Yes.
Now come to page 58.
Yes.
This is an agreement which is made on 8/12/75.
Yes.
And above, there's a date which is called dated Jakhama, dated 14th December 74.
Yes.
Now, can you tell me which is the date of this? What is the date we should consider? Whether it is 14 December 74 or it will be 8/12/75. Which is the date we should consider?
So far as the earlier proceedings before this court, this date of 74 has been considered.
74 has to be considered.
Yes.
Therefore, you see, if I can give you a simple example, you want to, not you, in fact, you means A, for example. A wants to purchase the land from B. He enters into a agreement for sale, say on 1st of January. After that, preliminaries are over, and on 2nd of January, a sale deed takes place. Now, whatever is there in the agreement will lapse, and the sale deed, the contents of the agreement of that sale deed, that will prevail. Correct?
Yes.
You have an agreement at page 58 that says that, well, I will get a service. Now, when you enter into this page 47, which is a deed of release, you relinquish that. You see, please read it, page 47 with me.
I understand.
Correct.
Yes.
So once page 47 prevails, then perhaps you cannot fall back on your agreement dated, this agreement is, this agreement would have lapsed in light of page 47.
But the manner in which the agreement was executed, if your lordship reads, it was based on a promise granted by the government to the landowners, saying that if they donate this, yes, based on a certain amount of compensation,
That's
we
what I
will
said.
first give you appointment.
That's why I
Based
said
on
I
this,
find it very difficult to convince me.
your lordship, but based on this, more appointments have already been granted. Now, including this respondent has also been granted.
You know,
on the
Contract
basis
Act,
of
I'll
land
show you
ownership.
something. Give me Contract Act. Section
And
21 of
If
the
you-
Contract
if
Act.
your lordship, yeah. Now this, the manner in which this appointment has been granted has also received the imprimatur of the division bench of this court in the earlier proceeding, based on which the division bench had directed the department to go for advertisement and to invite all the landowners, only the landowners, to be accorded or to compete for this post.
We understand that, but we would be bound only if the legal interpretation is correct.
Where is the
No.
division bench judgment?
Yes.
It's here. This
It's
one.
a page 76.
This is the, I was searching for it. This is the. I was reading this one. Now,
Now the entire exercise has been taken on the basis of the direction passed by the division.
we understand, we are not, right now we're just interacting.
Yes.
We don't want to put anything without putting you to notice, that's why.
The direction is at page 9.
See this, give
Page
it to,
76, paragraph 9.
Closer.
yes, this, please give it to him. This is section 21, 20 and 21 of the Contract Act.
Yes, but this position has not been contested by the state.
No, we
State
understand.
admits the position that they have promised, granted us promise, now the principal
No,
promise.
but you see this promise, that's why we are putting you a question. We'll take a short break and come back. You see, that is the question to you. What happens to the promise if it is not translated into a final agreement which has to prevail? That's why I gave you an example of agreement for sale and a sale deed. Because if you don't keep that agreement for sale alive in your sale deed.
But if your lordship may appreciate it, what has happened during this time? Now, we do not know whether the full compensation has also been paid to the landowner. Now, it seems from the agreement, it appears that it was not paid, but they have parted with the land on the promise of the government.
For that, you see, the only.
And the state does not deny that.
Is, no, it's okay.
Over the course of the years, 4 appointments have been made.
No, it's
This
okay.
respondent has also
Now,
been made. on
I'll
the
give you
basis.
another example before we take rest and come back. You see, A enters, the last example I gave, A entered into an agreement with B for purchase and sale of land. The A, who is the seller, in good faith parts with the possession of a land. B, being unscrupulous or scrupulous, whatever you say, does not give the entire money, but the sale deed is executed. Please tell me whether the sale deed is void.
Come again, your lordship, I did not get it.
A wants to purchase a land. He enters into an agreement for sale with B. B is the owner of land. B, in good faith, on execution of the sale deed, transfers and delivers possession of the land to A. Correct? Now, this B does not get the entire money. A is not an honest person. He does not pay the full amount. So let us take, for example, agreement was for 100 rupees. This man paid 10 rupees. A paid 10 rupees only. B transfers the land of 100 rupees to A, receiving part consideration of 10 rupees. Now, 90 rupees is unpaid. Now, according to you, is
That
the
that
state
is not
valid or
my
not?
case, Your Lordship. That is not my case.
Hmm?
That is not the case as far as this bill is concerned.
No,
We are
I'm
not
just
disputing
asking you a
that.
question. Why that can be your case? We'll come back. Just like TV commercials, we'll come back, come after a short break.
Yeah.
You see that section 2021 we referred to was merely a facade. It is merely a facade to confuse you. When I refer to 20 and 21, you see the reason is why we are saying it is that an agreement with which is mistake of fact is void. That is not your case because within 3 years you did not come to the court to take back your land. Therefore, this land has been relinquished in favor of the government. That's one. Second, if this agreement is valid and this agreement for sale is overridden by the actual deed of release, then you are hit by the principles of acquiescence, waiver, and estoppel. Because this condition which is there in your agreement for sale was not incorporated in the deed of release. So this is a question we are posing it to you. We are adjourning the matter. Be prepared on the next date.
Your Lordship,
Next week.
notice is here to be issued. Notice is here to be issued. This is
No,
this is
we are not issuing a notice. That's why we are deferring it. Because if we have this view, then it will lead to a dismissal.
No, then in that case, your Lordship will also have to consider the appointment of the respondent number 5, who has been accorded based on this agreement.
We take it up next week. Do it because this is a question which we'll have to respond to.
But since, if I may, this already has the imprimatur of the early division bench, if your Lordship wants to take a contrary view to this, then
No, it's not. It's not that. You see,
present my arguments.
well, you see, what is the issue before the division bench? Division bench says that you follow it, and this perhaps escaped their notice. So therefore, will still not be bound. It's not a disrespect to the earlier order of the court. It's a question where we interpret it and say that this matter could not have been the legality could not have been there to send it in the manner which has been done, and therefore not being bound by the principles of law. We'll merely say that the earlier bench, it was never pointed out before the court that this deed of release is in fact a transaction which refers to money, and therefore it's not a gift, and therefore this agreement we consider it was not be 16.8, not even follow. And it's not a question of disrespecting or taking a view, because that legality of that agreement was never gone into.
Then in that case, next week I may be permitted to address this court on the question
Yes,
of
we are adjourning
if
it.
the court feels that a different view is to be taken, then the matter may have to be referred to the CG.
We adjourn it next week. Both sides are represented. We are not putting this question. My sister is here. You will also know. Both of you are knowing this, what issue has come up. Because if we pen it down, it may be difficult for you to address us. That's what it presented. On the prayer made by Bedlam Council for the appellate, list on. Next week is 17th, 9/2025.
For orders, item number 5.
Lordship, since a night of April 2025, the movies as well as has been served to the respondent number 1. But till now, the respondent number 1 is yet to enter appearance. So Lordship, I pray that notice may be considered to be deemed complete and rule may be issued. Lordship.
Passing numbers for legal service. Trying to see the cases. We have to see the notice was issued in 30 days time. There will be section 27 of the Civil Process Act. They would don't have the. So I understand. There are reasons why we are unable to accept notice to be deemed to be duly served. There are two reasons for that. Number one, notice was issued on 9/4/2025, and the notice was issued on 10/4/2025, immediately after next day. But we don't have the postal receipt number, and the track report is not there.
If you see on.
You can collect the postal track report and then give it to us, then we'll accept it, because nowadays AD card doesn't come.
True. Lordship, otherwise on 11/9/2024, on 11/9/2024, her counsel, she appeared and the delay was condoned. Thereafter, she withdrew. 11/9/2024.
11/9/24.
Maybe in the IA.
In the IA.
This is the IA.
And the appeal has been admitted on that day, Lordship.
But the presence of the respondent is not recorded.
The counsel is in Tilonja, Lordship. Her counsel, respondent number 1 counsel.
You see this order?
11/9/2024.
Yes.
But the order doesn't reflect the presence of.
Presence of the counsel is not recorded.
It is not reported.
Otherwise, on that day,
The Vakalatama is.
done, the appeal was.
The Vakalatama is not on record. We'll just show it to him. Show it to him. And please check if the Vakalatama is on record. Vakalatama in the IA. In this IA, whether it is on record, I did not find it.
Not
Huh?
there, not-
It's not there. But in our central registry, is it reflected appearance of MT Longshar advocate in this matter? In our central registry, that computer?
If that is the case, Lordship, at least this matter after.
No, there are reasons why we are cross-checking it. This is from what is it? This is once it is appears in the mind. He is continuing the holy patient. So once he appears. And this also in the way you listen to so this handshake is please give me this CPC, Civil Procedure Code. Civil Procedure Code. Petition decrease one so and so. Can I pay the degree? So this is going to be. I told you again this one. Petition, we provide the civil proposal to us. It's like paying. Unless he reduces himself. The section 67, 68, chapter 5. We continue. This is what we get. Ask you to get the postal receipt number and submit postal track report from the website of postal department. Because we don't have the record of the.
No, the registry will
council-
do the tracking.
Okay.
Registry.
Otherwise, even me, I
No.
don't have the poster because we
Because they file
filed the
it.
Salabana here.
That's why we are saying you'll have to collect the postal receipt number from the registry and submit the postal track report. Because here we don't have adequate staff. We can't employ a court staff to give that checking and all. You do it and give it to them. They will put it into the file. You'll get the postal receipt number. seen that the service report on the respondent number 1 is still awaited. So
You'll
accordingly,
have to get the
we-
registered AD number, no? The tracking number.
permit the learned additional advocate general for the state or her representative to collect the postal receipt number from the registry regarding notice issued on 10/4/2025 and submit postal track report prior to the next date of listing. We'll fix it next week.
Lordship, in that case, this after 2 weeks, Lordship.
No, you can get it today and after half an hour, you can get the track report.
Lordship, next week I'll be out of station for after 2 weeks, Lordship.
Okay. Okay, list after 2 weeks.
Lordship, I meant to mention, during item 26, in Lordship, I'm not quite keeping well today, so Lordship, even we.
26.
The respondent is not around, so I pray that this matter will be listed after 2 weeks, Lordship. Item
Okay.
26.
You will from the other side.
The council is not present, Lordship.
Okay, we'll take a note, but we won't pass ex parte order. We'll take note of that, you are paying for adjournment. We'll pass orders when we reach the item.
Lordship, I pray that this matter may be listed after 2 weeks. I'm not quite keeping well
I
today.
am understanding. We are not taking up the matter, but ex parte orders, we are not inclined to pass. Let the matter reach, then we'll pass.
Let someone else be there, one government.
Other side should be here. Correct.
For orders from the supplementary cost list. For admission, I beg your pardon. Admission from the supplementary cost list, item number 29.
Yes.
No application of names. Lord, this appeal is directed against the Indian judgment and order dated 13/8/2025, passed in WPC number 50 of 2023. Matter was heard on 5/11/2024.
Which is the,
12/11/2024.
which page is that order? Which page is that order?
Page.
The challenge you are making is
Yes,
there,
that is at page 317.
317.
But before I come to the Indian order.
Yes.
A brief background will be necessary because there has been 2-3 litigations before this.
Yes.
Now, but before I come to that also, I'm referring to the date of hearing. Hearing was done on 5/11/2024, 12/11/2024, 13/11/2024. That was one page. Thereafter, after a few months, on 10/2/2025, it was listed, it was through virtual VC. And on that day, the councils were directed to file certain arguments. After again a few months, it was last listed on 23rd of June 2025. On that day, a question was put to all the councils that whether you have anything to say. Before this, the Lordship is well aware, Lordships are well aware that the Honorable Supreme Court has passed an order that once a case is kept CAB, it should be disposed of within 3 months like that. So maybe in view of that, who knows, this may happen. Recent, I don't know. But that was the sequence. And after more than 8 months, the judgment, Indian judgment and order was passed on 13th of August 2025. And Lordship may have seen, there has been a lot of contradictions in the judgment also, with due respect, Lordship. And coming to the facts, Lordship, the petitioner was appointed as a computer in the Department of Economics and Statistics. And then he was taken to the Department of School Education in the year 2003 on deputation as a postgraduate teacher. But some problem with the seniority dispute, some seniority dispute arose. with regard to the counting of his seniority, from which date he should be counted, seniority should be counted. Either it should be from the date on which he was brought in liquidation or the date of cabinet decision. But then the department has given an arbitrary date. Therefore, he was compelled to file a writ petition before the Honorable Court, which was registered and numbered as WPC number 107 of 2012. And that came to be heard on 3/9/2013. And then an order was passed fixing the date 2013. Yes, for counting his seniority should be from the date on which he was brought into petition, that is 2003. So far as counting of his seniority is concerned, it was determined from 2003. That is the date when he was brought on deputation. And this order has not been challenged by anybody. But one development has taken place during the pendency of the writ petition is the juniors, his contemporaries, who are postgraduate teachers, they were given promotion during that time to the post of principal.
Just a moment. I have a query. Let me ask you that first.
Lord.
We find that in the impugned order,
Lordship.
there is a reference to the Lokayukta and Upayukta.
Yes, I'll come to that, Lordship. Yes, I'll come to that because that is very relevant. That is passed in the writ appeal number 1 of 2024. I'll come to that, Lordship, by a division bench of this Honorable Court. So, other juniors were promoted to the post of principal. After that, only the matter got disposed of in the year 2013. Therefore, the petitioner submitted a representation that look, during the pendency of the writ petition, my juniors have been promoted to the post of principal. So my case may also be considered in terms of the judgment passed by this Honorable Court, which was passed in WPC number 107 of 2013.
2012.
2012, and order was passed in 2013.
4/9/2013.
Thereafter, the promotion was effected on 17/7/2014. By that order, the petitioner, along with the private respondents who were added as respondent number 4 to 9. So they were also promoted to the post of principal. That was on 17/7/2014. Now, in that promotion order, in respect of the petitioner, the representative in the column, it is clearly reflected that this promotion is in terms of the order passed on 3/9/2013, passed in WPC number 107 of 2012. And this order has not been challenged by anybody till date. So that remains. Now, what happened? After that, after about 6 years, in 2020.
No, but please tell us what has happened after that order of 2013. What is the date when this seniority was considered?
Seniority.
The date you gave?
That was sometime in 2014.
2014.
Yes.
There you say that there's a remark that it is being considered as per the High Court order.
I submitted the representation to consider my promotion because all my juniors were promoted to the post of vice principal during that time when the writ petition was pending. My case was not considered in view of the pendency of the writ petition. Therefore, my case was considered only later on when it was due for promotion to the post of principal. Therefore, all of us by a common order were promoted on 17/7/2014. All of us were promoted by a common order, and in respect of the present appellant, in respect of the writ petitioner, there was a column on the extreme right-hand side in the order itself saying that his promotion has been done pursuant to the order dated 3/9/2013, passed in WPC number 107 of 2012. And this remained as it is. In 2020, what happened? Some of the juniors who feel aggrieved to file a complaint before the Lokayukta. Actually, it should be a complaint to the department. Maybe they may have some connection there. So they filed a complaint before the Lokayukta alleging certain irregularities with regard to my certificate of PN and also on the seniority dispute. Instead of approaching the department, instead of approaching the parents, he has opted to approach some trainer so as to adjudicate their problem in the house. That was this. So Lokayukta was very happy to take up this.
Lokayukta must see the video today. You will find it, if it is live streaming, you will find it very offensive.
No, but I'm narrating the fact.
No, it's okay.
Narrating the fact. Why I'm saying that maybe they have some connections. Why? Because by violating the provisions of the Lokayukta, who is supposed to be the guardian of the Lokayukta Act, who is supposed to be conversant with the entire provisions, he has acted which he do not have the power to do. That is why I'm saying this. Otherwise, plainly, I cannot just make any submission. When he do not have the jurisdiction, he has assumed jurisdiction. And in the interim recommendation, what the Lokayukta has said, this order of 3/9/2013, passed in WPC number 107 of 2012, has attained finality. When it is final, what is the point of recommending to the department to revoke my officiating promotion? On one hand, the Upper Lokayukta is saying that this order of 3/9/2013 has attained its finality. On one hand, he is saying that. On the other hand, in violation of that, his own order, he is again sending a recommendation to revoke my promotion. My promotion is basing on the order passed on 3/9/2013, passed in WPC number 107 of 2012. And Lokayukta has arrived to a finding that yes, this has attained finality. But at the same time, he has sent a recommendation to revoke my promotion, and department was waiting very happily that there is a recommendation by the Lokayukta, so we will cancel his officiating promotion. And accordingly, my promotion order has been cancelled by the department. Agreed by that order, the writ petitioner approached the Honorable Court by filing WPC number 50 of 2023. And then, as I was narrating, the order was passed after about 8 years. Maybe our memory is very limited, so there is chances of forgetting. I don't blame anyone because even myself also, I have limitation that my memory cannot retain for so long. Whatever I have submitted, whatever my learned friend has submitted, it is not possible to retain. So possibly because of that, there has been contradiction in the orders. And by reading the paragraph 29 and 30, in between there is only 3 inches in between. On one hand, at the end of paragraph 29, the learned single judge has arrived to a finding that there is a departmental proceeding pending against the petitioner.
There was a focus notice issued against you.
After 5-6 lines, he again came to a finding in paragraph 30 that the department has not initiated any disciplinary proceeding against the petitioner.
But the show cause notice was issued to you. DP was started by issuing a notice of sometime in 22.
Yes.
Of relying on a manufactured document.
Complaint. Now, when we come to the Lordship's query, the writ appeal. This is with regard to the interpretation of Section 9. And why I'm referring to Section 9? Because Section 9 parts the Lokayukta to investigate.
I'm missing a link again. In the was this order of the Lokayukta assailed by the petitioner?
Yes.
Where is
The
that?
entire proceeding has been assailed.
Where is that?
Challenged.
In the writ petition.
In the writ petition, yes.
Okay, that is your first prayer. Proceeding of Lokayukta bequest. That is your prayer, number 1. Okay.
Proceeding of Lokayukta against the petitioner in case number so and so, 13 of 2020. And then the order dated 28/1/2021, passed by Honorable Lokayukta, that is the interim recommendation to revoke my
And please tell me,
officiating promotion.
but please tell me, this order of the Upalokayukta was on 28 January 2021.
Yes.
Why it took you more than 2 years to challenge that order by filing this writ petition in 2023?
Till that time, Lordship, till that time, my promotion order was not revoked. My promotion order was revoked only in the year 2023. That is why I filed a writ petition in 2023.
Sitting on the fence.
No, unless I'm agreed, I cannot come. Once I approach this honorable court may say that no, writ petition is premature. You have not made out a case, writ petition dismiss. So I thought it appropriate that I should not add something which I should I should be at the receiving end. Lordship.
But the recommendation was already there, Upalokayukta
But
recommendation.
what happened to the DP?
Yes.
What happened to the departmental proceedings?
Departmental proceeding is pending. It is pending. Why I'm referring to the writ appeal number 1 of 2024 is to make clarity on the implication of the section 9. We have to be very clear.
Section 9 of the?
Yes, that is with regard to the jurisdiction of Lokayukta, which cases can be investigated by the Lokayukta, which cannot be, because there is a bar. But learned single judge went by deciding the case by relying on section 8. Section 8 is subject to section 9. So let us see what is the implication of section 9. Lordship will find that order at page 47 of the writ appeal. And the order is dated 29/5/2024. I will refer only to the relevant paragraph, Lordship, because that will assist your Lordship.
Where is the act? You are referring to section 8.
Yes.
8 is not quoted in the order. We starts with
8
9.
is quoted, Lordship, in the order.
It starts with section 9.
339.
3?
It is quoted. 339.
339.
338. The chief minister or minister or a secretary, a member of the state legislature, vice chancellor or registrar of a university, chairman and vice chairman by whatever name called, or a member of the authority or board or a committee, a statutory or non-statutory body, or a corporation established by or under any law of the state legislature, any other public servant. The Upalokayukta or Upalokayukta may, if it is fit, investigate an action taken or with a general or specific approval of a public functionary if it is referred to him by the state government.
Okay. In view of the nature of challenge in the writ petition, we are inclined to issue notice in this matter. Because we have doubts regarding the power of the Lokayukta to entertain this complaints of this sort.
Then the learner single judge has also agreed with the finding of the learner single judge in WPC 107 of 2012, which was passed on the 3rd of September 2013. it has attained its finality. So Lok Ayukta as well as the learned single judge in the imbued order has categorically stated that this order has attained finality and nobody has challenged. And besides that, there are limitations also, Lordship. Limitation, when there is an grievance, it is 12 months. And when there is an allocation only, that is 5 years. Who counts?
Because the Lokaयुಕ್ta has no business about the promotion.
Matter.
Service matter is not the authority. That's number one. Number two, if he has done any mischief of submitting false documents, fake documents, you draw a disciplinary proceeding. But on the basis of Lokaयुক্ta order, this promotion could not have been stayed or revoked. You should notice in the matter.
I have filed an IA also, Lordship, for stay of the exam judgment.
Heard, Mr. City Jamil, Lanet, Senior Counsel, Assistant Minister.
I am Chen.
I
am Chen.
Lanet Counsel for the appellant. As well as Inari, Lanet Government Advocate.
Additional Advocate General Behavior Ratio.
Okay. Okay. Appearing on behalf of
Additional AG P. Shukri.
Ms. V. Sukrit, and Additional Advocate General. Appearing on behalf of the respondent numbers
Entry.
1, 2, and 3. Filing this intra-court appeal, the appellant, who is the writ petitioner in WPC 50 of 2023, has assailed the judgment and order dated 13/8/2025, passed in the said writ petition. Disposed of the writ petition, thereby having effect of permitting the Lokaयुক্ta, Nagaland, to proceed in the complaint before it, before the said authority, under the provisions of section 8, read with section 9 with the bracket 3 of the, what is the act, name of the act?
Nagaland Lok Ayukta Act 2017.
Nagaland Lokaयुক্ta and Lokaयुক্ta.
Lok Ayukta only.
Only Lokaयुক্ta.
Yes, under Lok Ayukta, there is Lokaयुক্ta below that. So, but Act is Nagaland Lok Ayukta Act 2017.
Okay, yes, 17. Next paragraph. Although the learned government advocate has admitted admission of the writ petition, of this appeal, but on a privacy view that with regard to promotion, the service of the appellant as in our capacity as the officiating promotion of the appellant to the post of principal of which school?
That time he was posted at Government Higher Secondary School, Oka, but now he is posted in Moon. Since petitioner is fighting with the department, of course, it is the liability of government servant to be posted anywhere, but he has been sent to Moon.
Okay.
Now at
Who was,
present he is
earlier posted in
Oka.
in government school,
Government Higher Secondary
School Oka, and presently posted in
Government Higher Secondary School, Moon.
Mon is regulated by the which service law? Promotion is
Regarding
covered by which service law?
Nagaland School Education Service Law.
The Nagaland School Education Service rules.
Yes.
Which year?
Nagaland School Education Service Rules 2017.
2017. Which by implication can be constituted to be an ouster of jurisdiction of the Upalokayakta in service matters. The court is inclined to admit this inter-court appeal for hearing by issuing rules returnable forthwith. Of the requisite extra copies of the writ petition shall be served on the government advocate within in respect of respondent numbers 1, 2, and 3 within 2 days. The appellant shall take steps for service of notice on respondent numbers 4 to 9 by registered post with AD. Most of the notice is made returnable on, give a date after 4 weeks. 8th October. So that will not be 4 weeks, more than 4 weeks. It will take 1 week time to make it 5 weeks. 1 week for taking steps and then. Hmm?
15 is 4 weeks. 15 is 4 weeks. 22nd.
24th. Okay. 20. Today's.
Today's 10th. If it's 5 weeks.
15?
If it's 5 weeks, it will be 22nd. 4 weeks, it will be 15th. Eight.
So 15th we can give to on 15, 10, 20, 25. Of the learned counsel for the appellants is permitted to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. List on so and so. So just before the last line, to say that the observations made in this order is only a prima facie satisfaction and not the final opinion of the court, and therefore none of the parties shall be prejudiced when the matter is heard on merit.
Lordship was referring to the role that is in the context of we have for the inquiry and disciplinary action, the discipline and appeal rules that is followed. But the service rule, we are governed by Nagaland.
Service rule, we are not on this.
Then that is okay.
Okay, just also say before the, no, not the IA. Heard so and so for the applicants and so and so for the government advocate for the respondent. Appearing on behalf of the learned additional advocate general for respondent numbers 1, 2, and 3. As no, just say, but on the prayer for interim relief, which is opposed by the learned government advocate. However, considering the nature of grievance raised in the connected appeal and taking into consideration that though the order of promotion of this of the applicant was passed pursuant to and in compliance with the order dated
3/9/2013.
3/9/2013, passed by the learned single judge of this court in WPC
107 K of 2013.
107 K of 2013. The court is inclined to stay the operation of the implement judgment in order dated 13/8/2025, passed by the learned single judge in WPC 50 of 2023. Next one. No, it's better. We have done a mistake. Before that, before this, no, we're not disposing it out. In the second paragraph, you write, you should notice on this interlocutory application for interim relief, the notice is made returnable on 15/10/2025. The applicant shall take steps within 2 days for service of notice on the respondent numbers 4 to 9 by registered post with AD. Next, by the learned counsel for the applicant is at liberty to correct the postal receipt number and submit postal track report prior to the next date of listing. Then this interim relief, heard so and so, and then interim. Next, based on 15/10/2025. Sir, this in the before the last line, just also say that this order shall not come in the way of the authorities in the school education department to proceed and conclude the disciplinary proceeding that has been initiated against the applicant. Last one is list on so. This will continue.
Police report awaited. Awaited. Pencil cutter करते हैं अपनी क्या हाँ तो पढ़ने को पाएगी For orders, item number 7.
May I please worship? My lord, I beg to mention, on behalf of this so-called additional AJ, my lord, I beg to mention item number 26, my lord.
She made a mention.
Yes, kindly
Can
list
you
the
ask-
measure after 2 weeks, my lord.
Both says are represented on the prayer made by the learned additional advocate general. Matters to adjourn today, list after 2 weeks.
Much obliged.
Very pleased, my lords. The lordships, the interlocutory application number 20 of 2025, this is for condonation of delay of 235 days
Yes,
of preferring this appeal.
the notice is not yet served.
The lords, on 19 August 2025, we have served through registered notice, but we do not know whether the notice.
No,
was
the report is there, it's not served.
My lord,
It's return of service is awaited. Since this is a criminal matter,
my lord.
I just a moment.
So this is books only. Has to go to the police station.
Okay, under the notifications of the High Court, Mr. Sheki, this under the notifications of the High Court,
My lords,
you take steps through the jurisdictional police station.
my lords.
That is the requirement. So route it through your police and that will be served by the police station, OC, and returned to you. This is state appeal.
State appeal.
Oh, no, you're not the state. I thought you were the state.
My lords, I'm one of the councillors for the High Court Legal Services Authority.
Okay,
You have to
okay.
take steps through
Where is the
that
APP? Where is the APP? I'm sorry, I mistook you for the,
My lord,
you're the APP?
Yes, my lord, but I'm not
Okay.
handling this case, my lord.
No, whoever is,
Okay.
but we require your presence.
Yes, my lord.
Correct, whether you are engaged or not, it is solely on you. These steps taken by the applicant will be routed through the registry and handed over to your office. You will serve it through the jurisdictional police station, which is
Dimapur.
this is fast track court, Dimapur WN police station.
Dimapur Women Police Station.
So this will go through them, correct?
Okay.
This is as per High Court rules. You're appearing as legal aid counsel.
yes, your lordships.
Heard Mr. Joshua Sekil, learned legal aid counsel, appearing for the applicant. Also heard Mr.
ETPA, public prosecutor.
E.
ETPA, home.
E. Tipa Home,
Oh,
EHO.
yes.
Okay, learned APP for the state.
Public prosecutor, my lord.
Acha, learned public prosecutor of the state. Although the learned legal aid counsel has taken steps for issuance of notice on respond number 2, but as per office note dated 8/9/2025, the return of the service report is still awaited. Next para, accordingly, the court is inclined to direct the Learned Legal Aid Council to take fresh steps for service of notice on respondent number 2.
Two, my lord.
Full stop. The registry, after processing the notice, shall hand over the copy of notices along with the copy of this interlocutory application as well as the connected memo of appeal to the Office of the Public Prosecutor, Nagaland at Gauhati, Kohima Permanent Bench of the Gauhati High Court. Stop. On receipt of such steps, the Office of the Public Prosecutor shall transmit the same to the officer in charge of Dimapur Women Police Station for onward service to the respondent number 2. Stop. Next para, steps shall be taken within 3 working days. The notice on respondent number 2 is made returnable on, give 3 weeks time. No, 3 weeks will be. Eighth, okay. On 8/10/2025, so the officer in charge of Dimapur Women Police Station shall ensure that the service report is returned on time for being placed before this court. Next para. List on 8/10/2025.
My lords. Bless your lordships.
Much for it.
For orders, item number 9.
And I have instructions to appear for the respondent, sole respondent.
Sole respondent, okay.
And I will be filing objection to the IA filed by the appellant.
Okay.
Applicant.
Your name?
Adjournment.
Okay. Both sides are represented. Next, Mr. Jamir, Learned Counsel, has entered appearance for the sole respondent, and he prays for some time to file his vakalatnama as well as the affidavit in opposition in this interlocutory application. So accordingly, matter stands adjourned today. List after 2 weeks.
2 weeks, man.
List after just a moment. There's a delay. How many days? There's a delay.
Delay, no sure.
How many days?
166, if I'm not wrong.
$199 days.
199 days. Okay, 3 weeks. List after 3 weeks. Give a fixed date. This is better. 3 weeks will be 8/10. 8/10. The affidavit shall be filed at least 2 days prior to the legislative listing.
Also, item number 10 also similar.
Same. Here also respondent number 2.
Sole respondent.
So sole respondent, okay, sole respondent, same order. Okay.
For hearing, item numbers 23 to 25.
Episode হয়ে যাবো। Yes, which is the notification you are challenging?
My lordship. My lord, item 23, 24, 25. These are listed as analogous matter for hearing. Before filing WPC 2222 of 2022, the petitioners have filed 232 of 2021 and 237 of 2021. Challenging, praying for to maintain common seniority list for both branches called armed branch inspector and armed branch inspector under the same directorate of police. So now, while pending these two matters, read petition before the land single bench, through affidavit filed by the state government, had brought to the court that the branch-wise seniority of both inspector and police have been maintained and distinction has been made as per Rule 33 of Police Manual. So we came to know through that. Now
33B.
after that, yes, now after
33B.
that, Rule 33, as per government's affidavit at para 5.
Yes.
Now, after coming to know that the present petitioner have filed WPC 222 of 2022, challenging the police manual itself.
You are challenging 33B.
Yes, 33B now. So this is the case. So now, as I have said, the members of the petitioners as well as prior respondent, they are all from the same family, police department, under the same directorate of DGP. My lord, what happened is this. In WPC 222 of 22, there are altogether 17 inspectors of police who are from an armed branch. The private respondent, they are from armed branch under the same DGP. Now, the grievance of the petitioner armed branch is that since we are from the same establishment, same directorate, why classification, why branch-wise?
Answer is very simple. Answer is very simple.
Yes.
I'm saying it in a lighter note, we're not very serious about it. Because the armed branch people are at more risk than an unarmed branch. I'm saying it in a lighter note, not very serious about it.
Yes. So now, I'll just give the short facts here. Now,
Just my apology, just. Lordship, may kindly come to page 69.
69.
This is rule 1 of the police manual. Page 69, your lordship has noted.
Yes.
It provides for division of force. What your lordship is said is here. The Nagaland Police District Executive Force is divided into two main branches, vis-a-vis unarmed and armed branch. The strength of these are separately laid down for each district. 2. The armed branch comprises of this following: 3. So the duties responsibility discharged by them are totally different. So as per rule 1, armed branch and unarmed branch are two separate and distinct category, your lordship. And therefore, rule 33B, which is under challenge, provides for separate seniority list. And this rule 1 is not being challenged.
That's okay. Let him have the privilege of arguing.
Yes. And in fact, the whole police manual, according to my submission, is not enforceable in terms of the rule, the law. I'll show the adjustment. Now, in this case, especially in this, the rule challenging the rule, the issue to be considered by reasonable court is whether the Nagaland Police Manual dated nil, year nil, comes into force with effect from the date on which it is printed in the government gazette or from the date it is made available to the public. This is the issue to be considered by this court. I have a judgment from Supreme Court that will settle everything. If the judgment, the pronouncement of Supreme Court is reliable here and applicable, in that case, the police manual itself is not enforceable. That's my submission. Yes. Now, my lord, the short fact, just background, without opening the file, I'll just explain. Lordship will easily understand. These inspectors, they are from the same family, like I said. Now, by advertisement dated 23/03/1999, post of sub-inspectors, assistant sub-inspectors, Hovilder were advertised. There, no distinction was made that you will be armed branch, unarmed branch. Seniority will be separately maintained. Nothing was mentioned in advertisement 1999. It's a common advertisement. These are facts I have already narrated in the writ petitions in my pleadings. Then thereafter, my lord, next fact is, based on that advertisement 1999, select list was published on 25/06/1999. Even there in the select list, no distinction was made between
Yeah, the police manual.
my lord, advertisement is page 25. 24, 25.
No, I'm requesting for this as a Nagaland police manual.
Manual. We have all the buzzers manual. No year, no that, which they have circulated and sold to all the advocate members. No year, no that, no that. It doesn't bear, even the gazette notification is not part of their manual. I have all the books. Normally, lordship knows very well. Any book published by any statutory law, the gazette notification is part of that.
This is you have which police act is applicable here? 1961, which is the parent act.
We so far we don't have any service rule.
No.
We are following this manual. I couldn't do that.
We need the first volume.
Police Act is there, I think.
Police Act. You have the volume 1. Ask in a library if we have this volume 1. Police Act is 1961.
Yes, I'll just go with a facts, short facts like that. Only 4 points.
Yes.
Now, after the common advertisement, in the common advertisement, no distinction has been made between the two branches, unarmed branch and armed branch. Now, even the select list published on 25/06/1999, no distinction.
Most of them say okay, this is ordinance is part 3. Just a moment.
This
Just a
book-
moment.
This book has been sold to almost all the advocates who are practicing.
But
And
the,
there
but you know something. In the bar, maybe perhaps 5% have read it. They don't read this.
as per the law, the gazette publication should be part of the statutory rule or law. Here, gazette publication is not part of the manual. Note that no year of printing is not mentioned. Date of printing is not mentioned. Gazette
This
publication
is,
is not part of.
we don't know about this because what happened was, this was originally a part of the Assam Police Manual.
It's a
After that,
copy-paste.
no, not copy paste. In most of the states in the country have similar manual. Plus minus some of it, you will find what you call this, Puducherry having a better manual. Punjab is having a better manual. These two I have noticed. Others I have not read it, but I'm trying to show you something. No, it's not here.
The primary issue, as I have said, is that the issue to be considered by this court is whether the Nagaland Police Manual dated nil, year nil, comes into force with effect from the date on which it is printed in the government gazette or from the date it is made available to the public. That issue has to be considered. Once that is considered, then there is applicability of Rule 33. Rule 1 will
Yes.
My lord, short facts without opening the paper. As per the,
Yes.
after the
Same thing. I don't know. Doesn't have. Yeah, yes.
So now, my lord, after the common advertisement, selection was made. Even the selection result, there was no distinction between branch wise, means an armed branch inspector, or sub-inspector. So we were all taken together as one.
Just tell me, I'm just trying to understand. Let us say, we're testing this argument. For example, territorial army, when they make a recruitment, they don't say that you will be selected for X unit, Y unit, or whatever is that is not there. So it is the internal departmental administration which says, because if we accept this part of the argument done so far, we are not seeing the Supreme Court judgment, then what happens is that under the Assam Police, this Nagaland Police Manual, you also have placements of the officers, armed branch, unarmed branch, and there are hierarchy prescribed. And that is something which is there since the state of Nagaland adopting this Nagaland Police Manual. Can you say, because you when you were selected and posted to the unarmed branch, and you knew about you're expected to know about the service law, you did not lay a challenge when you were appointed and posted to this, because conveniently from the date of your appointment, you were there in the unarmed branch. And therefore, these strenuous duties were never allocated to you. That may be what you call, I have not seen this, but few of the work which the armed police branch would do is to assist the law and order, to combat uh, insurgency, and then to be there in the active security and escort duty. There's one or two more I forgot. So these are the primary work, and people who are in this assigned to these duties, they do not have, if I'm not wrong, a prescribed duty hour. For example, a traffic police, unless he is assigned an additional duty on a particular day, they have a roster of hours maintained. Every police station, if you go, they will have a board stating that how many armed branch personnel are in duty, unarmed branch is in duty, what is their duty time, and what will be the change time. Those things are normally written in the police stations. So the fact is that when you join, that time you never protested.
Lordship will appreciate one fact. In Nagaland, since 1999 advertisement, till now there's no certificate. Till now there's no certificate. So therefore, the facts is different, my lord. My lord, if I'm allowed.
Yes, yes.
Now, after selection was published on 25/6/1999, I have said no distinction has been made between the two branches, like unarmed branch as well as armed branch. Now, even in the appointment orders were issued on 5/05/11/99. It was categorically recorded that the seniority list will be maintained as per marks secure, means on merit basis. Lordship will see in the read between page 31 is the appointment order. Appointment order. Page 31. Page 31. The last para. What the department say about seniority position? Page 31. The entire seniority of the above mentioned direct sub-inspector of police will be determined on the basis of the marks secured in the recruitment test. This is my case. Now, even in the appointment, there is no distinction between armed branch and unarmed. It's a general law and common law that the appointing authority has inserted this provision that even after selection of the sub-inspectors, their seniority shall be determined on the basis of merit, based on merit in the recruitment.
Yes.
Now after that, my lord, after appointment was issued, all the private respondent as well as petitioner were sent for training in Shillong, Training Center, Police Center, Northeast Police Academy, 2020, 2000 and 2001. Upon completion of training, petitioner were posted as an armed branch OC of all police stations because we are meritorious in the exam. All those who are meritorious in the exam, they were posted as OC of police station. Unmarried student candidates were sent as with rifle armed branch. Now, after whose fault is this? Just because of my meritorious career, I have been posted OC to perform the discharge the duty of OC. Then unmerited candidate had been sent to the Butland as armed branch sub-inspector. Now, with this posting, branch-wise seniority, separate seniority started maintaining. This is how we are agreed. This is the grievance. Now, because of this grievance, we were before the government saying, no, you have posted us as a meritorious candidate as OC, and less merit candidate were sent as armed branch in the Buckland. Now you have started maintaining two separate seniority lists for two branch. And now, as we are aware that the strength of the cadres are more in Buckland, so therefore, when maintaining separate seniority for armed branch and unarmed branch, due to more strength in armed branch, the less meritorious candidate got promotion 100 times faster than me. This is my grievance before the government. Now in 2010, this grievance was addressed by the government home department, OM dated 9/3/2010, laying down the guideline that determinations of seniority in the rank of sub-inspector shall be based on the feeder grade, meaning sub-inspector. So whoever is senior in the rank of sub-inspector, they will get promotion inspector. So till such time, till 2010, there is no distinction between armed branch and unarmed branch. Now, for the first time, after 2010, my lord, for the first, my lord, the 2010 relevant page is page 40. Page 40. Relevant, I'm referring to page 40. Last paragraph. The policy, the OM has laid down the guideline for maintaining seniority for the post of inspector as and the sub-inspector. May I continue? My lord?
Yes, yes, yes.
Thereafter,
I have a bad habit of multitasking.
my lord.
So I am hearing you. Don't.
Relevant portion in the OM.
OM.
The
2010
memorandum
OM
of 2010, yes.
Then the next. Relevant paragraph. Last paragraph.
Last paragraph. Seniority of these between question be determined. Okay.
Then the government of Nagaland.
What is UBI?
UBI means unarmed branch. Meritorious candidates. Unarmed branch.
Inspector.
No, we don't make a comment whether it's meritorious or not.
That is my submission. As per the result, we are meritorious. Based on record. My lord, after 2010 government OM, whereby seniority in the rank of sub-inspector and sub-inspector shall be maintained as per the seniority of the feeder grade. Now, the next point comes. Government of Nagaland by OM dated 14/03/2014 for the first time has made distinction between an armed branch inspector and armed branch inspector. Now, till 2014, there is neither service rule nor manual. Where is the source of power to come up with this office OM 2014, making distinction between an armed branch inspector and armed branch inspectors? There's no source of power to issue this office memorandum of 2014. There has to be a source of power to issue this office memorandum 2014. There is no source of power in absence of service rule, in absence of police manual at that point of time.
Yes.
So these are the facts pleaded in writ petition as well in the present writ petition. Now, the petitioner had come to know when the petitioners filed these two writ petition 232 of 2021 and 237 of 21, the government has filed affidavit contesting the case that particularly at paragraph 5 of the government affidavit says that no, this distinction has been made as per Rule 33. They don't say Rule 31, Rule 1.
Just a moment. This is. This process also.
Now, my lord,
Just a moment.
Yes.
Just a moment. Is it okay? And this. Does not say what is for you. If it is coming later. So that's the way it is.
So now it's really, it's sort of instruction.
Which is not, which is not good of you. No, service to which is not good of you.
Yes.
The big choice that you feel very.
Now, my lord, for maintaining two separate seniority lists for the same cadre, how petitioner have been denied and deprived, discriminated in matters of promotion. I just show my lord, 2 copies I have prepared. My lord, the first page is petitioners. First page is petitioners.
Give a copy to Mr. Jamir also. Otherwise.
Just release the book. Because this is based on facts.
No, it's okay, but Mr.
My
Jamir
lord,
was right.
Now, first page is petitioners. The chart below will show the entry point and date of promotion of the read petitioners 1 to 17 who enter as sub-inspector on armed branch pursuant to a common advertisement dated 23/3/1999. Petition 1, Nicole Audio, entry point, sub-inspector 5/11/99. Then date of promotion is 5/9/13. 1999, he got appointed as sub-inspector. Till now, he's inspector. So these are up to 70. Now, they got only single first promotion after 2026 years. Till now, they're inspector. Only one promotion. Now, my next page, just to give the correct picture, how petitioner has been discriminated. The chart below, next page, my lord. The chart below will show the entry point and date of promotion of the private respondents 4/5/18 who enter as armed branch sub-inspector pursuant to the common advertisement dated 23/3/1999. All I'm showing so a date of appointment is as sub-inspector same. Then promotion, they got promotion quickly in 2007 as inspector. Then now the DYSP. Deputy Assistant Command, USP. Now, down below also, all 3 of them. Then next page. So this is how, this is the difference. This is the grievance. They are all uniform forces. Now, next page 3. The chart below will show the entry point and date of promotion of the private respondents 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, who enter as armed branch assistant. This is not sub-inspector, 1 star, assistant sub-inspector. Pursuant to the common advertisement dated 23/3/99, Lordship will see they enter as 1 star, 1999 by the same common appointment advertisement. Then they got promotion to sub-inspector in 2002. Then they got inspector in 2009. Then deputy command DYSP in 2024. 3 times ahead of us. Now they are senior to us in rank as well as in post. Now next page, page 4. Page 4, my lord. Continuation. Continue all this. They were in DYSP now. We are still inspector. Then let's come to page 5, my lord. Page 5. These people enter as constable, my lord, in the same by the same appointment. Common advertisement.
In this 222 of 2022, the state has not filed any affidavit. 222 of 2022, state has not filed any affidavit. Then this non-traverse, we admit it. Why should we hear it?
My lord, here.
We'll allow the writ petition. Why should we hear it? If for 3 years you don't file an affidavit.
My lord, here I'm appearing for respondent number 1 and 3.
Yes.
And 2, 4, and 5.
So state does not oppose this. State does not oppose this writ petition. Oh, my sister said it is filed.
I have filed my affidavit. I am for 2, 4, and 5.
2, 4, and 5.
This is 2, 4, and 5. No, the
2,
state.
4, and 5 is state.
This is the Special Secretary Home.
Home Department.
Okay. And state.
There are 3 writ petitions listed. Item 23, 24, and
Yes.
25.
Okay,
Now-
Principal Secretary Home has filed. Okay, we omitted it. We thought it was a. Okay. Okay, it's there, it's there. It's there.
Item 24 and 25 was initially filed before the limits single.
We understand that. In this case, these pleadings are complete. Now he says that now he has challenged the rules, and therefore this is 222.
222 of 22.
Okay.
That is item 23.
Okay.
However, his submission is in writ petition item 24 and 25, not in item number 23. Yes, Lordship.
Okay.
His submission his submission pertains to item 24 and 25, not in 222, Lordship.
Okay.
Where rule is under challenge.
No, he's making the submission on rule only.
Facts, just to show the facts before the court.
He's saying the
Fact are
facts.
saying.
He's saying the fact because if he's deprived of promotion for so many years, I think that he must get it. I mistook it. I thought that number 1 is not filed and therefore no controversy. Okay.
My
it's there,
lord,
it's there.
you'll read number 2.
I've seen that. I've seen
Number
that.
2 here, I've received instruction that will rely on the submission
Okay.
made by the.
Okay.
phone number.
Okay, I missed it out completely. Okay. Yes.
So my lord, I'll come to the law as I have raised this issue. In this case, the issue to be considered by the Supreme Court is whether the Nagaland Police Manual dated nil comes into force with effect from the date on which it is printed in the Government Gazette or from the date it is made available to public. I'll just show one. I'll show only one judgment that allow me to read the facts. Facts are similar. This is SEC 1998, volume 8. Facts are similar. Law has been laid down very clear. Choosing of date. whether publication of gazette should be taken as correct or the date on which it has been brought to public is important. Once this honorable court accept this principle, then this will settle the matter instead of going into the facts of the case. I'll just read the facts short, only paragraph 12. Facts are very similar, very close to the present case.
Yes.
1998, volume 8, page 250, page 250. 250, my lord, page 53. 253, I'll read paragraph 1. May I read it? Yes. Important facts that here. Same case here. In this batch of cases, the question that arises for consideration is whether a central excise notification comes into force with effect from the date on which it is printed in the Government Gazette or from the date it is made available to public. This is the issue to be considered by court in Supreme Court. 2. To illustrate the circumstances in which this question arises, we will state the facts of civil appeal number so-and-so 1989.
Can I distinguish it in a moment? You know, sir, I'm just referring without showing it to you. Article 13 says notification is also a law for the timing in force of the Constitution. Article 13. Just give the Constitution. Now, just give it.
My lord, Article 13.
Article 13.
Article 13, man.
Yes.
Laws inconsistent with or in derogation of the fundamental rights. 1. All laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall, to the extent of such inconsistency, be void.
You avoid that, come to 3. This article, unless the context otherwise requires.
In this article, unless the context otherwise requires, a law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. B. Laws in force includes laws passed or made by legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas.
Yes. Now you see, this case refers to New Tobacco Company is a case which is notification about tariff. Under the Excise Act, I forget the section 38 or something, that says that every notification must be published in the official gazette.
Not only that, should be brought to the notice of the public. Only then it will be enforceable.
That is, once it's published in the gazette, it becomes, there's no more requirement to further publish it. Not under the act.
Here, one step further, not only publication date, it should be that date should be taken from the date it was brought to the notice of the public. This is the judgment I'm trying to.
No, it's okay, but that's not the point. The distinguishing factor is that this police manual is merely a rule which is required to be followed by the personnel. That's one. Number 2, for example, a draft service rule prepared by any authority which is not brought to the brought into the public domain by issuing a notification. I'm trying to understand from you this draft service rule, whether it can be followed or not when even if the state has not adopted it.
No. Draft rule. In my respective submission.
But there are many authorities on the point. Draft service rules is acted upon.
Yes.
If I'm allowed to read this judgment, this judgment has given the
No,
distinction.
that's why we are telling you in any taxing statute, for example, this excise, income tax, the GST, the act is is not very illustrative, but these notifications which come from time to time, that makes it a huge volume. So therefore, under the Excise Act, there's a specific provision which says that all notifications must be published in the official gazette. You know how this this Nagaland Act, Police Act, is envisaged. You're aware of it, but still, I'm asking you: are you aware of how this Nagaland Police Act is structured? You know it? No. Please read the act. You will find that very surprisingly, I was surprised when I saw it is always called NAP Act. So why it is NAP Act was a query which I had once upon a time. And then I found out the name of the act is Nagaland Armed Police Act. You know of it? So in fact, unarmed police is not even envisaged under the Nagaland Police Act. And all the provisions of the Nagaland Police Act, because I was just surprised, why NAP? Nagaland Assam Police or something like that. That was an inquisitive query I had, and I found out this NAP is Nagaland Armed Police Act. Now, unarmed police is not even a part of this act. Now, therefore, if you, technically speaking, I'm not arguing with you, but technically speaking, how does an unarmed branch for which the act is not made can be fitted in? Then I found out that if you visit the site, state government, you will find there's a chart given. I've downloaded it for you. This was published in this Nagaland Act of 6 of 1966 is the Nagaland Armed Police Act. Then if I can come to this is a document which is available in the Assam, in the Nagaland Police website. That's why I told you when you were submitting, I was doing something. I have a bad habit of multitasking. You see, this is what is there in your Nagaland Police, and then 5 or 6 rows below. See Assam, the Nagaland manual, and the statement made against that. So therefore, this is a rule which is prevailing, continuing, and the government has acted upon. And once it is acted upon, well, a challenge is maintainable, no doubt. We can't say that your challenge is not maintainable. The challenge is maintainable. But the fact is that this is what has been prevailing. And this Nagaland Police Act, you wanted, if you want, I'll show it to you. This, please give it this. Nagaland Armed Police Act.
Police.
No, I'm not disturbing your argument. You please continue. But I'm saying that when you are referring to this
As far
Assam Excise, this Excise Act.
as far
Excise,
as arms act are concerned, we are not covered by that act.
no, I'm not saying that. I'm for a moment not saying that.
My lord.
I'm just making a query. This, how is the fitment? How is the fitment? But it doesn't matter at all because your argument is otherwise sound. When there is a scope of two people being treated in a different manner, definitely you have an arguable point. But when it comes to this excise, I have my reservations because I don't know this act. You have the India Excise Act. Because in the Excise Act, unless it is published, the duty is not in the public domain, and therefore it is not. That is the ratio in this case.
Even in this case, government says, police say that this police manual was of 2010. But now they're saying it was published in Gazette in 18, but it was never brought to the notice of the public. This is my view. May I continue?
Yes, please.
Paragraph 2. Because this factor clause is similar, and the law discussed in this case is similar to this. Now the contention of the opposite party is that it was only published in the Gazette in 2018. Therefore, this is enforceable. I'm saying, yes, that this Supreme Court has made the distinction between publishing in the Gazette and the date bringing to the public notice is different. May I read paragraph 2, my lord?
Yes.
To illustrate the circumstances in which this question arises, we will state the facts of civil appeal number so and so. The company involved in this appeal is the New Tobacco Company Limited. It was earlier known as Duncan Tobacco Company. It is engaged in manufacturing cigarettes. Since 1979, it used to pay duty on cigarettes manufactured by it at the rate fixed by Central Excise Notification number so and so, that is 13/1979, as amended from time to time. It was rescinded with effect from 30/11/1982 by notification number so and so, that is 30/11/1982.
It's not required. Not required. I have it. Just show it to. This is.
This case can be differentiated.
So there is a legal requirement.
My lord, this distinction has been given this judgment. That's why I just want to show to the court. So that after that, I'll link it to lordship. May I continue, my lord?
Yes.
Between 30, middle part of paragraph 2.
You have reminded me of these things. Maybe I'm taking note of this act after perhaps 20 years.
Yes. My lord.
During practice time, I had some few matters of excise. And I'm recalling this after 28, 30 years, 20, 25 years.
My lord, I'll continue. In the middle part, between 30/11/1982 and 8/12/1982, the company cleared 79.456 million cigarettes and paid duty of thereupon at the rate fixed by the notification dated 1/3/1979. As it did not know that a new notification was issued on 30/11/1982. As the company had paid duty at a lesser rate, a show cause notice dated 22/12/1982 was issued, calling upon the company to show cause. Why? he should not pay the differential amount between the duty short paid and the duty which has become payable in terms of the new notification dated 30/11/1982. The assistant collector, by his order dated 11/4/1983, confirmed the said demand. The order of the assistant collector was upheld by the collector of Central Excise on 4/10/1985. It then appealed to the Customs, Excise, and Gold Appellate Tribunal. The only contention pressed by the company therein was that their notification dated 30/11/1982 was made available to the public on 8/12/1982, and therefore duty at the enhanced rate could be lawfully demanded from it only from 8/12/1982. My lord, this is relevant. In support of its contention, the company had produced a letter dated 2/8/1983 obtained by its sister concern MS National Tobacco Company from the Controller of Publications, Department of Publication, Ministry of Finance, Government of India, which stated that notification number so and so that 30/11/82 was placed for sale to the public on 8/12/1982. The tribunal relied upon the said letter and the decisions of the Bombay High Court in GTC number so and so held that publication as contemplated by Section 38 of the Central Excise and Salt Act 1944 and Rule 8 of the Central Excise Rules cannot be equated with mere printing, and it is the availability of the printed material to the general public that constitutes the required publication. This is my case. Taking this view, it further held that the excess recoveries of the duty made during the period from 30/11/1982 to 8/12/1982 cannot be retained by the authorities, as the company was not liable to pay duty at the rate fixed by the notification dated 30/11/82 and for the said period. The Controller of Central Excise has therefore filed this appeal under Section so and so. 3. It was contended by the Learned Counsel for the appellants that the only requirement of Section 38 of the Act is that all the rules made and notification issued under the Act shall be published in the official gazette. Thus, publication in the official gazette is the only statutory requirement. This notification is dated 30/11/1982, and the gazette in which it was printed also bears the same date, that is 30/11/1982. And therefore, that date should be regarded as the date of its publication. On the other hand, it was contended by the Learned Counsel for the respondent that publication cannot be equated with mere printing, and it is the availability of the printed material to the general public that constitute publication as required by the statute and the rules of natural justice. 4. Section 38 of the Act provides that all the rules made and notification issued under the Act shall be published in the official gazette. So, the requirement of Section 38 is publication of the rules and the notification in the official gazette. Dictionary meaning of the word publish as given in Webster Comprehensive Dictionary International Edition: to make known or announce publicly, promulgate, proclaim. 2. To print and issue to public. 3. To communicate to a third person. According to the legal glossary published by the Legislative Department, Ministry of Law, Justice and Company Affairs, Government of India in 1992. It means to make generally accessible for or available, to place before or offer to public, to bring before the public for sale or distribution. Thus, the word publish connotes not only an act of printing, but also further action of issuing or making it available to the public. Notification. According to Webster's third New International Dictionary, inter means, quote, 1. The act or an instance of notifying, intimation, notice, the act of giving official notice or information. 2. A written or printed matter that gives notice. The legal glossary referred to above defines it as a written or printed matter that gives notice. Even if we go by the dictionary meaning, the requirement of publishing the notice would connote that what is intended to give. What is intended to give notice or information to the public can be treated as published only when it is made available to the public so that they can know about it. The requirement of publishing the notification in the official gazette, which is an official journal or a newspaper containing public notices, and other prescribed matters also indicate that the word published in section 38 should be interpreted. 5. We will now refer to the decision to which our attention was drawn to be by the Learned Council in Haral Soyi. The facts were that a council of ministers appointed to look after the government and administration of Jaipur state during the Maharaja's minority passed a resolution which purported to enact the Jaipur Opium Act, and the question which had arisen for consideration of this court was whether the mere passing of the resolution without promulgation or publication in the Gazette or other means as known to the public was sufficient to make it law. The court referred to the rule prevailing in this behalf in England that acts of parliament become law from the first moment of the day on which they receive the royal assent. But the royal proclamation only when actually published in the official gazette and cited with approval the decision in John so-and-so case, wherein it was held that the order of the food controller did not become operative until it was made known to the public. This court also noticed that nor is the principle peculiar to England. It was applied to France by the court Napoleon, the first article of which states that laws are executory by virtue of the promulgation thereof, and that they shall come into effect from the moment at which their promulgation can have been known. It also pointed out that such a rule has applied in India, for instance, matters arising under Article 119, Rule 119 of the Defense of India rules. It then made an important observation that this rule was only an application to a deeper rule which is founded on natural justice. It has further observed that, quote, it would be against the principle of natural justice to permit the subject of a state to be punished or penalized by laws of which they had no knowledge and of which they could not even with the exercise of reasonable diligence have acquired any knowledge. Natural justice requires that before a law can become operative, it must be promulgated or published. It must be broadcast in some recognizable way so that all men may know that it is, or at that very least, there must be some special rule or regulation or customary channel by or through which such knowledge can be acquired with the exercise of due and reasonable diligence. The thought that a decision which in the secret recesses of a chamber to which the public have no access and to which even their accredited representatives have no access and of which they can normally know nothing, can nevertheless affect their lives, liberty, and property by the mere passing of the resolution without anything more is abhorrent to civil man. It shocks his conscience. In the absence thereof any law, rule, regulation, or custom, we hold that a law cannot come into being in this way. Promulgation or publication of some reasonable sort is essential, unquote. Now, para 6. Taking this view, this court held that a resolution of the Council of Ministers in Jaipur state without publication was not sufficient to make the law operative. 6. Instead of Maharashtra versus so-and-so, What had happened was that a German smuggler left Zurich for Manila by a Swiss plane on 27/11/1962 with 34 kilos of gold. He had not declared it in the manifest for transit. The plane arrived at Bombay on 28/11/1962. The passenger had remained in the plane. The custom authorities on search recovered the gold carried by him on his person. He was prosecuted for importing gold into India in breach of Section 8 Clause 1 and Section 23 Clause 1A of the Foreign Exchange Regulation Act and the notification dated 8/11/1962 of the Reserve Bank of India, which was published in the Gazette of India on 24 November. The respondent was convicted by the magistrate but acquitted by the High Court. One of the contentions raised by him was that a notification being merely subordinate and delegated legislation could be deemed to be enforced only when it was brought to the notice of the person affected by it, and that as the same was published in the Gazette only on 24/11/1962, whereas he left Zurich on 27/11/1962. He could not have had knowledge about the restriction imposed by that notification. This court, rejecting that contention, held that notification was published and made known in India by publication in the Gazette, and the ignorance of it by the accused who was a foreigner was wholly irrelevant and made no difference to his livelihood. Relying upon the decision, it was contended by the learned counsel for the respondent that it is the cardinal principle of the criminal jurisprudence that a person should not be convicted for an offense unless the person or persons affected by the prohibition are in the position to observe the law or promote the observance of the law. The said observation was made by this court in the context of mens rea being a necessary ingredient of the offense. In that very case, this court has observed that individual service of a general notification on every member of the public is not necessary, and all that the subordinate law-making authority can or need to would be to publish it in such a manner so that person can, if they are interested, acquaint themselves with its contents. 7. In the state of MP versus so, while interpreting the word publish in section 3(2) of MP Prathamik Middle School so. Quote, in our view, the purpose of section 3 animates the meaning of the expression publication is the act of publishing anything, offering it to public notice, rendering it accessible to public scrutiny, and advising of the public, and making known of something to them for a purpose. Logmakia exercises need not detail us because the obvious legislative object is to ensure that when the board lays down the syllabi, it must publish the same so that when the stage of prescribing textbook according to such syllabi arrives, both the publisher and the state government and even the educationists among the public may have some precise conception about the relevant syllabi to enable government to decide upon suitable textbook from the private market or compiled under Section 5 by the state government itself. In our view, therefore, publication to the educational world is the connotation of the expression. Even the student and the teaching community may have to know that the relevant syllabus for a subject is, which means wider publicity than minimal communication to the departmental official government. 8. Following this judgment, the Madras High Court in Asia Tobacco so held in such cases the effective date is the date of knowledge and not the date of official case. The relevant observations made in paragraph 14 of the said judgment are as handed. God. the mere printing of the official gazette containing the relevant notification and without making the same available for circulation or putting it on sale to the public will not amount to the notification within the meaning of Rule 8, Clause 1 of the rules. The intentment of the notification in the official gazette is that in the case of either grant or withdrawal of exemption, the public must come to know of the same. Notify, even according to ordinary dictionary meaning, would be to take note of, observe, to make known, publish, proclaim, to announce, to give notice to inform. It would be a mockery of the rule to state that it would suffice the purpose of notification if the notification is merely printed in the official gazette, without making the same available for circulation to the public or putting it on sale for the public. Neither the date of notification, nor the date of printing, nor the date of gazette counts for notification within the meaning of the rule, but only the date when the public gets notified in the sense the gazette concerned is made available to the public. The date of release of the publication is the decisive date to which the publication is effective. Printing the official gazette and sticking them without releasing to the public would not amount to notification at all. The respondents are taking up a stand that the petitioner is expected to be aware of the withdrawal notification and that the words published in official gazette and the words put up for sale to public are not synonymous, and offering for sale to public is a subsequent step which cannot be imported into the act. And the respondents are expressing similar stance. They could not be of any avail at all to the respondents to get out of legal implication flowing from one of due notifications, as exemplified above. Printing the notification in the official gazette without making it available for circulation to the public concerned or placing it for sale to the said public would certainly not justify the idea of notification in the legal sense. Paragraph 9. The same view was taken by the Bombay High Court in GTC, Industry so-and-so. 10. The following observation made by in the case of BK so-and-so also support the view that we are taking. Quote, whether a law is reviewed from the standpoint of conscientious, good man seeking to abide by the law, or from the standpoint of Justice Holmes, unconscientious, bad man.
Mrs. O, it's not taking us anywhere. You see, the reason is, number one, you have not been able to demonstrate in the first point that this entries in this police manual is a service rule required to be notified, because it doesn't say so. That's promotion and all is covered by chapter 4, I think. Chapter 4.
Rule 30.
4.
Yes.
Chapter 4. Part 3. It is in part 3.
Part 3.
Yes, it is in part 3. Yes.
Lordship.
Part 3.
Lordship, just allow me to read last paragraph 12.
No, you see, this is something when we are referring to this section 38 and all, you must understand that we are aware of it. Publication means, you see, when an act says it has to be published, then we follow the principle of what you call this? What is that case? It must be done in the manner and that manner alone. What is that? What is that case? I suddenly forgot. It's English. English.
In that manner and not
alone. So that is how I could forget. Okay. Shah, what do you call this? Nazir Ahmed makes that. So here you see, once you show that there is a requirement, then non-publication could be adverse. So first, you'll have to satisfy the court with regard to the requirement of a publication of a service rule and whether this, which is there in part 3, is a service rule or not. Since you are intensely arguing, we did not stop you. But this part 3 is which page? This will be which page? Part 3, okay. Page. Yes. Now this part 3, this is your book.
Well,
I'll just give it to him.
I have.
You have a copy?
I have.
It's okay. Now, look at this part 3. It's you see, we are showing you this because nothing in this manual. I'm sorry, I did not read this manual earlier. I draw my working knowledge from the Assam Police Manual. So here you see it is, this does not say that this is a rule, first of all. Or if under the Act this is not a rule, it's a manual only. Now, if I can draw a parallel, I'll tell you. The case I forgot. I'll get you.
Whether it will have a statutory force.
No, not that. You see, for example, this Central Bureau of Investigation, they have their CBI manual.
Correct.
In the case of Sasikala, the Supreme Court says that this has to be followed. Correct. And therefore, what happened was that the manual which was prepared for the purpose of investigation, and it was a handbook for the police officers, came to be known as a document which was scrupulously has to be followed. That was never the intention of this police manual. Now, in the Nagaland Police Manual also, this is, it does not say anywhere that this manual is required to be scrupulously followed. It's nowhere there. In the Assam Police Manual, it is not there. So I'll presume that in the Nagaland Police Manual, it is not there. That it has to be scrupulously followed. And this is number one. Second is, under the Act, there's a requirement of rules.
Right.
You have seen the Nagaland Act, Nagaland NEP Act. I have shown you Nagaland Armed Police Act.
So your worship, the manual is notified under 309.
309 of?
The Constitution. It has been notified under.
Then it has to have the governor's assent.
Yes.
Where is that?
Page 63.
663.
63 of the appeal memo.
63.
Of the writ petition. 63. This is writ petition.
Page 63. Page 63 of 222.
Writ petition.
Okay. This 222. 16. $53.
Yes. 63.
63. Okay. Okay.
And the date, which.
Okay. Okay, this did not come to notice.
My lord, therefore, since this rule manual, this manual was notified under 309 of the Constitution of India. Now that's what my contention is this. Whether this manual was published in Gazette, if yes, when? Whether that was made known to the people, whether in our books, whether this Gazette publication is part of the manual or not. Whether it is part of the manual or not. Because the notification is dated nil, year nil. That's what I'm just coming distinction, just paragraph 12. If your lordship allow me to read the same judgment, paragraph 12. The distinction is here, paragraph 12. Then lordship will decide whether my submission, my argument have the substance or not. Paragraph 12 of the same judgment. May I just read it? My lord?
Yes, yes.
Paragraph 12. Just that paragraph, 2 sentences. Then lordship will declare whether this manual is enforceable or not in the eye of law.
Yes.
Lordship, paragraph 12, may I read it?
Yes.
We hold that a central excise bulletin can be said to have been published, except when it is provided otherwise. When it is so issued as to make it known to the public, it would be a proper publication if it is published in such a manner that person can, if they are so interested, acquaint themselves with its contents. If publication is through a gazette, then mere printing of it in the gazette would not be enough. This is my case. Unless the gazette containing the notification is made available to the public, the notification cannot be said to have been duly published. Paragraph 12. Lordship want to consider paragraph 12. That is my case. My argument, whole argument is that this Nagaland Police Manual, which was stated to have been published under Article 309 of the Constitution of India in 2010, if it was so, then whether the Gazette publication is part of the police manual or not, one. Even if it is deemed to be published, then paragraph 12 of the judgment which I have cited referred now. Unless, even if it is published in the Gazette, unless the Gazette containing the notification is made available to the public, the notification cannot be said to have been duly published. This is my case. Now, all the members of the bar will have this, and there it doesn't contain Gazette notification, and this was sold to us. So the notification was never made known to us. Only one copy was filed before the court. That, in my respectful submission, members of the bar, whoever have been asked to purchase this, it doesn't contain the pages, it doesn't contain the date of printing this manual, it doesn't bear dates, no notification, no Gazette notification is annexed part of this manual now. So therefore, as in terms of Supreme Court judgment, paragraph 12, it cannot be treated unless the Gazette containing notification is made available to the public. The notification cannot be said to have been duly published. Now, how to make the Gazette to the public? How to make the Gazette available to the public? By annexing the Gazette memo notification here. Only then we advocate, we those users will know, yes, it is published in Gazette. So therefore, my whole contention is this: this manual has no force in the house law. It is yet to be enforced. This is my solution in terms of paragraph 12.
Incidentally, at my home, everybody who has any document preserves this very well. But I'm not aware that after independence, the Constitution of India was distributed free to all. Brought to the notice of
The
every
government of Nagaland keeps on issuing such notifications in the Gazette every month. So, according to you, how should it be made known to the public?
According to judgment, Supreme Court judgment, unless
No. It says, you see, this is a qualified paragraph. It says, please read from the top. It says a notification under the Excise Act. So it doesn't say a notification under any act. This is one. Second is, incidentally, again, outside our scope of deliberation, in India, there is no act to govern the printing of a gazette. Are you aware of it? There's no act under the government of India for publication of a gazette. But two states have it. One is the earlier state of Rajasthan. It has a Gazette Act of 1956. And there's a Gazette Act of the state of erstwhile Jammu and Kashmir, which requires that all government notifications must be published there. Incidentally, for the country, there's no act, because earlier it was published under the British government. Then we became independent. We are publishing it. But incidentally, I have not come across any act. And it is not there in the public domain, at least. Even if there is an act for Gazette, it is not in the public domain. Two notifications will come out when you check the Gazette. A Gazette of India Act 1945, which is for Jammu and Kashmir. And Government of India Act 1950, sorry, the Gazette Act 1956 of State of Rajasthan.
No, my lord.
So every act will say that it has to be notified in the Gazette. Now, incidentally, since you did not see that, we'll show you something. We referred you to the Nagaland Armed Police Act. There's a Rule 19. That is why we try to not allow you to complete your reading of this act, this judgment. This is Nagaland Armed Police Act, Section 19.
The government may make rules for carrying out the purposes of this act. 2. Without prejudicing the generality of the foregoing powers, the rules may provide for the following matters, that is to say. 1. The number of battalion/companies to be constituted. 2. The pay and other terms and conditions of service of.
Yes, that's all. For your purpose, this is all. So you see, government may make rule. Now, this also says that every rule made has to be laid before the parliament. But what happens when a governor makes a rule under 309 and not laid before the parliament? Under the 309 rules, it can't be said to not have force merely because it's not laid before the parliament.
My lord, my only submission is this. This is the manual. To make known, lordship has put a query to me. How do we know? Now, the law is that how do we make this notification publicly available? You don't need to do anything. Just incorporate the Gazette publication in this book. Then all those users who are interested, who are likely to be affected will know that yet this become the law. So therefore, my reply, my argument is this. I'm not demanding that they should come door to door and give us. No. Once they want to enforce this manual, the Gazette publication should be part of this manual. This is my short and humble submission. Without publication, without making that Gazette publication part of this manual, then Lordship will put a question. How then my opinion, how do we know? And we have been using, but we don't know that it is published in Gazette. Because Gazette is not part of this manual. This is my point, man. This is my point.
We go back to the English principles. King can do no wrong.
Lordship will see example, just one simple instance. This is education department. This is education department and employment department. How Gazette are published now? Just I first draw Lordship's attention to employment. So Gazette is always part of the service rules. Next page, man. Gazette is always part of the rules. In exercise of power conferred by proviso so and so, article so and so, the government so and so. So this not Gazette publication is always part of the rules. Same thing in education department. I have something this. Okay. Education department, my lord. Next page. Second page of the education department. Nagaland Gazette extraordinary published by authority. Notification. That is so and so. So therefore, in all the rules, once it is published in Gazette, the Gazette is always part of that manual or rules framed under Article 309 of the Constitution of India. This is my claim. I repeatedly, my argument is consistent. If the rule is made and if that notification is part of the manual, then I have no argument. I have no argument. So that's simple, my lord. In every service rule, any statutory law published under framed under 309 of the Constitution, the Gazette publication is always part of the rules or manual. But in the Nagal, in this police manual case, in the police case, the manual which they have sold to all of us does not have the Gazette publication. Therefore, we are in the dark. So unless the user, the people who are likely to be affected are well informed that it is published in Gazette, it becomes law, enforceable. How do we know that our rights are affected that much?
I think your lordship, in that case, the petitioner needs to file an affidavit that in the Gazette notification, that manual was not made part of the Gazette notification.
Why not? This is a question of law. I don't file any question of law.
What?
No, it's not there. Otherwise, you would have given it.
Yes.
Negative can't be proved by him.
Yes.
Page 12.
Page 63, that only the Gazette notification is there. And manual, that is the annex. Now, in the Gazette notification, whether in the notification that the manual was part of this notification or not,
No, that
he
is
is
for
saying
this-
that it was not part of this notification.
That is, you see, for the state to show. Negative can't be proved.
Yes. Now, that is his statement. That is his statement, and that was not the statement made in the writ petition, your lordship. That is a new ground which has been taken,
My
your
lord,
lordship.
it's not new ground. If lordship come to page 12 of my writ petition, page 12, paragraph 5, I have made a specific plea here. Pleading is there.
Paragraph
Pleading is
5.
there. Paragraph 5, page 12 of my writ petition. May I read it, my lord? That the petitioner state that prior to the publication and notification, the Nagaland Police Manual was never put into public domain, calling for its plain objection. Hence, the present writ petitioner were not aware about the said notification on publication on 31/8/18. Therefore, the provisions of the said manual to which the petitioner are agreed could not be challenged could be challenged only at this plea. I have made that plea. That plea has been taken. I'm not hiding. If I have not made any statement, then yes, I may be required to file.
It was never put in the public domain for inviting claims and objection, and it is not necessary. And that is the statement made in paragraph.
Very well, if it requires, I'll file affidavit also, no problem. Because this was not part of the manual. The Gazette public is not part of that. That is on record. If requires, I'll file affidavit, no problem.
Yes, and what is your response?
Okay, Lord. On the authority relied upon by the petitioner, Your Worship, 1998, 8 SSC, page 2. Now, in my respectful submission, one, the first issue in that is the date with effect from which the rule will come into effect, Your Worship. That was one. May I take Your Worship to page 63? Page 63, Your Worship. Just to show Your Worship. Determining the effective date. That was one of the issue in the authority relied upon by the petitioner. The Lordship has come to page 63. Writ petition 222. Lordship is on page 63. Your Lordship.
Yes, yes.
Page 63. Your Lordship may kindly see notification is dated 8 March 2010 and Gazette notification, Your Worship, is 31 August 2018. Your Worship has got it on top. So one of the issues is 1988 SCC 250 relied upon by the petitioner is the effective date from which it will come into effect. So whether it will be, the police manual will be with effect from 8 March 2010, that is the notification date, or on which date the notification was notified in the Gazette, which is 31st August 2018. Now, now, Your Worship, the ratio of a decision has to be considered in the light of the facts of the case, Your Worship, that is the settled principle of law. Now, the authority which has been relied upon by the petitioner, Your Worship, it relates to fiscal policy, Your Worship, which affects the public in general. And unlike the service rules, which relates to only the member of the service, Your Worship. So, on bringing to the knowledge of the person who is going to be affected or who is to be governed by the service rule, Your Worship, now it is sufficient to bring to the knowledge of the members of the service who will be affected by the notification, Your Worship. And in my respectful submission, the petitioner was aware of the rules, the manual, even prior to filing of the writ petition, connected writ petition, Your Worship. May I take Your Worship to the affidavit in opposition filed in writ petition 232.
232.
Affidavit in opposition filed in writ petition 232, Your Worship. Now, in that case, Your Worship, by the private respondents. There, I would like to annex one order passed by this honorable court in writ petition 129K of 2015. Even prior to filing of this writ petition, the petitioners were aware of the manual where 33B is mentioned.
32 page again. 232.
Writ petition 232, affidavit in opposition, filed on behalf of respondent number 7, private respondents for question. Writ petition 232, affidavit in opposition, your lordship.
Yes.
Now, my lord may kindly come to page 39. Page 39, there is an order dated 15/3/2017, passed by this honorable court in writ petition 129A of 2015. Page 39. Lordship has got it.
Yes.
Page 39.
Yes.
Yes. Now, relevant portion, I will just take where rule is mentioned, page 41. Fifth line.
Yes.
Further, Rule 33B of the Nagaland Police Manual Part 3 clearly indicates. Your Lordship has got it?
Yes.
Yes. Now, here, Your Lordship, the petitioner number 9 is petitioner number 12 in writ petition 232, connected writ petition.
The respondent number 9.
Here. Here in writ petition 232, Your Lordship, the petitioner number 12 is one Bandang Samba.
Yes.
Petition number 12. So this petition number 12, Bandang Samba, he is petitioner number 9 in the writ petition, which I referred to. Petitioner.
Yes.
Yeah. This is the old resolution, part of the manual. In the earlier repetition, 129, Bandang Samba, he is petitioner number 9, Your Lordship. And this writ petition was filed in the year 2015, Your Lordship. And the petitioners, they are here before Your Lordship in this writ petition saying that they were not aware of the manual. The petitioners are not before Your Lordship with clean hand, Your Lordship. That is my humble submission. See, the fact that the manual is notified, look at this. And then it has been already brought to the knowledge, the petitioners were aware of it. But unfortunately, in the earlier writ petition, maybe there, due to some lapses, they did not challenge the rule. And afterthought, writ petition 222 has been filed challenging the validity, the virus of Rule 33B of the Nagaland Police Manual, Your Lordship, without challenging the basic rule, Rule 1. So the submission advance, Your Lordship, regarding the manual, Your Lordship, is not legally sustainable. This is before, without going to.
When you made that statement about not coming with good hand, with clean hands, I just remembered in a judicial proceedings before the High Court. And what do you call, the petitioner had made a statement that the respondent has not come with clean hands. The reply of the respondent was that this is a blatant lie in the writ petition that I have not come with clean hands. Before drafting of this affidavit, I had washed my hands, sanitized it, and therefore I have written this with very clean hands.
Only on that part, if Lordship allow me to reply, because that is need to be clarified.
It's okay.
That need to be clarified. Lordship will appreciate now.
No, that's just one. Let him complete.
All right, sir.
Let Mr. Zamir take his seat.
That's all yours. Now, so far as the manual is concerned, my submission only to that, I'm confined to that. Merit, let the lordship, once you hear the merit, then I'll reply on that. But so far as manual is concerned, that according to him, manual was never notified, never was gazetted, and then the manual was never part of the gazette, your worship. And it was never brought to the knowledge. They were. So it has no force in law. That is the submission which has been advanced. To counter that, my submission is this. So the authority which has been relied upon by the petitioner, your worship, firstly, it relates to determination of the effective date, your lordship. Because that was a fiscal policy for with effect from which date it will come. Because now in this case, your lordship, I say, so that is not relevant, your lordship. Whether it will come with effect from the date of the notification mentioned or with effect from the date of the with effect from the date on which it was notified, published in the Gazette, your lordship. That is one. Secondly, your lordship, ratio of a case has to be taken into consideration in the light of the effects of the case. So far as the authority relied upon by the petitioner, it relates to fiscal policy, which affects the public at large, your lordship. Unlike the present case, the manual, the service rule, which governs only the member of the service, your lordship. So it is not necessary to bring it to the notice of the public at large if the member of the service knows about it. It is brought to the knowledge of member of the service. That itself is sufficient, your lordship. And as for the record, as reflected in as early as in 2015, in the order passed by this honorable board, the petitioners, they were aware of the manual. They're aware of Rule 33B, your lordship. So it cannot be said that it was never brought to the knowledge of the petitioner, so it has no force of law. That submission, advanced, your lordship, in my respectable submission, is not legally sustainable, your lordship.
Yes.
My lord, my learned friend has make a very strong statement that I have not come with clean hand. Now, I'll just show lordship. The manual, police manual was notified in 2010. Page 63 of my report, notified in 2010. But it was never published in Gazette. And yet they are enforcing this manual. Now, lordship will see again, this manual was stated to have been published in 2018, 31/8/2018. Now, at that time,
even before that, 2015, they were aware of.
No, my lord, I'm coming to that. In 2010, it was notified that this was framed under rule article 309 of the Constitution of India. But since that was never published in Gazette, so therefore it was not enforced. Now, this writ petition was filed in 2015. This writ petition was filed, which the judgment has been shown. This was filed in 2015. And that time, at that point of time, this manual was not published in Gazette. So therefore, what is the necessity for anybody to challenge this? In fact, in 2015, when this was filed, the council who appeared in this case did not bring to the notice of the court that this is not gazetted. Therefore, the court was made to pass this wrong order, relying that this was only published in gazette. That was the impression given to the judge. As we all have come to know that this gazette was stated to have been published in 2018. So even before that, they have used this manual as if it was published in gazette. So therefore, they have taken the shelter of this manual, which is wrong, and based on such wrong submission, court was made to pass this wrong order. So therefore, now the question, where is the question? Where is the question that the petitioners have come before the court with unclean hand? They have come before the court only when this manual was stated to have been published in the Gazette in 2018. That much I want to clarify on the question of law. Now, 2010, as I have said repeatedly, notification was issued in 2010 that it is this manual framed under Article 309, but since they have never published, now taking advantage of this judgment.
Doesn't give you any advantage. The reason is, before the adaptation of the Nagaland police manual, it was the Assam police manual which was being followed.
Yes.
So therefore, this state, since its inception in 1962, always had a police manual.
So therefore, the question that I had come with unclaimed, that doesn't arise because this manual was published allegedly published in 18, which was never made known to the people, like I have shown the books today. It was not part of the manual. So there were till today, all of us, police officers, they were not aware that this is really published in Gazette. Why? The Gazette is not part of the manual. The people sitting behind us, they were not aware. All officers, inspector, assistant sub-inspector, they were aware that this manual was published in Gazette because this is not manual. Gazette is not part of this manual. This is repeatedly, consistently I am saying on this. And now in 2015, how can they make a submission before the court that this is the enforceable law while it was not gazetted? So based on that wrong submission, this order was passed. Court was made to believe that this is enforceable in 2015. This is the whole issue. Yes, my own board. That much.
Lordship, I've just brought to your knowledge about the fact that regarding the manual, it was your knowledge way back in 2015. Now, may I take your lordship to that order again? The order passed by the Sonoko Court in 129 year of 2015. What did the court say about the manual, Rule 33B?
You see the last paragraph.
The affidavit.
Page 41. Last paragraph of page 41.
Yes.
You've seen that?
Yes, page 42. Yes. Last paragraph continued, page 42.
Yes.
The considered opinion that the said rule provides for having a separate seniority list with regards to armed and unarmed parties. This is the finding. This is the observation of the court here also. And no appeal has been preferred against this.
No,
this court.
That's beside the point. Mrs. O was making an intense argument. We were not stopping it. But you see, the fact remains that in the police, there are two branches.
Yes.
And they follow the two different modes of promotion. Can you come to that provision again? That seniority
of armed branch and unarmed branch.
Please come to that.
That is a different issue, Your Worship. So far as
Yes, that's on merit. We are going into everything. This petitioners are of what rank?
Inspector, presently inspector. Only one promotion they got during 26 years of service. 26 of service, they have got only one promotion.
Now please come to in this description of reserve. If you come to the pay and appointment of non-gazetted officers, all the petitioners are covered by that. Rule 6 to 15, part 3.
Part 3.
That is at page 8 of part 3.
Part 3.
Yes.
Pay and appointment.
Pay and appointment of non-gazetted officers.
Yes.
You are covered by this rule or some other rule?
There is no other. No
This-
service rule.
No. This is the provision only.
Yes.
Now you see, direct recruitment of sub-inspector. Then there's a training of probationary sub-inspector and their pay.
Yes.
9.
Yes.
10, armed branch sub-inspector.
Yes.
And it says that appointment of armed branch sub-inspector will be made from amongst the havildars. There will be no direct recruitment of armed branch sub-inspector.
Yes. If it is armed branch, we are an armed branch.
Unarmed branch. So unarmed branch is covered where?
Armed branch, direct recruit, sub-inspector is direct.
Unarmed is direct recruitment.
Yes.
And numbers will be rule 19 to 27,
19.
page 74. This is constable and no, enlistment. Pay and enlistment, not appointment.
Pay and enlistment of constable. That is 19 to.
No, the unarmed branch.
This is for the armed branch.
Regarding stagnation of service of unarmed branch, your lordship, yes, from the chart given, it appears, yes, there is stagnation, your lordship. But here the challenge is, they are challenging rule 33B. So, yeah, the issue is my respectful submission, your lordship will have to access the power of judicial review of statutory provision, your lordship. Honestly. The statutory provision, judicial review of statutory provision, that is what we need to go through. Now, whether articles rule 33B is liable to be questioned set aside, that in my respectful submission, that is the only issue which needs to be seen, your lordship. Regarding the stagnation of service, yes, from the chart given, your lordship, it appears. So if a more promotional avenue is made for unarmed branches, that is different. That is different.
No, that can't be. In a police force, you can't have a rank which is intermittent rank for one class of service police personnel and the other class. You can't have, for example, constable, then again a head constable or a sub-head constable.
Or by creating some more posts, additional posts that will maybe, that is. Lordship is right, but if some more posts can be created so that promotional avenues.
Now, for the purpose of promotion, do you have any exclusion test? That means some sort of written examination or some sort of
Common promotion test, CPT. CPT is a central promotion test is taken, your lordship, for promotion from the place of SI to sub-inspector. So the seniority also is taken into consideration as well as this CPT, central promotion test, your lordship.
My lord, to consider for promotion from sub-inspector. Rule 33, clause B. Clause B. A separate seniority list is maintained for both the branches for which separate central promotion tests shall be conducted by the police department under the Inspector General and Director General. This is my grievance. Because they are maintaining two branches seniority in separate tests. Whereas for us, 26 years, only one promotion. For them, the constable who were recruited with us by Kohima, that DYSP. So this is the statement. So therefore, discrimination is read large. Now, Lordship, may kindly see 53, page 53 of my repetition. How discrimination is continuously meted out. Page 53. Page 53 of my repetition.
Yes.
Notification dated Kohima dated 18 June 20. The governor of Nagaland is pleased to accord approval for maintaining the 28 is equal to 22 ratio, is to 22 ratio between armed branch inspector and armed branch inspector from promotion to the grade of DYSP. So now for armed branch 28%, for us only 22%.
Oh, that you can't have a grievance. Because
No,
before coming to court, we had a very good debate.
Just, I'm not saying that. Lordship, by maintaining the separate seniority list.
No, we understand. You see, that's why we are saying.
Yes.
That before coming to court, we too had a very good debate for some time on a very issue which is very touchy to both of us.
Yes.
You see, you know the ratio of appointment to the post of judges between the members of the bar and the bench.
Lordship will appreciate.
So
that they have that. I recruited
my sister wanted a consensus for 50-50. I was batting more for
my lord
advocates quota. So we just had a friendly chit chat.
In uniform service, Lordship will appreciate. In uniform service, I joined as sub-inspector. Was a person. Now, every constable that have become DYSP, where I'm still inspector, I have to.
No, we understand.
Very difficult for them.
Yeah, that's why we are thinking.
So otherwise,
especially in armed service, then it's very sensitive.
so then in fact the officers look at them. When we look at them, they are really frustrated, disappointing because constable who joined as constable in 1980, they are DYSP now in armed branch. Whereas people in the OC manning the office, controlling the crime, they are still inspector.
No,
So this is
recently they have also got promotion to the post of the OSP, Assistant Commander, in 2022, during the Ministry after this petition.
No, that is maybe one. Maybe one in the lot.
Out of 101.
Out of 101.
No, I have records of this. Promotion of it.
I have the chart shows.
Judge is different, I have reports. How many of them were promoted during the Ministry of this petition? Because in the motor pass and other two petition has been regulated by the Supreme Court and promotion.
My lord, that was based on the ratio 28 is to 20.
No, this is, you see, a contention issue. Not even in this. For example, for PWD also. People who are having diploma holders and then they come to the rank of junior engineers, and people who have graduate degrees coming and joining as junior engineers. Many get promoted and the others, they retire at the rank of junior engineers. We have seen litigation of those also. Works department also has this problem.
So far seniority and stagnation and promotion is concerned, Lordship, with petition 232 and this petition 237 will take care. However, Lordship, any other bus and writ petition 222, Lordship, will have a direct bearing in this writ petition. Therefore, Lordship, this two writ petition may be taken up after disposal of writ petition 222, where the Rule 33 is originally. Because in the two other writ petition, the
No,
petitioner
because there is a
is-
judicial order to take up three matters together.
because in other
When-
two
when-
writ petition,
when-
they are praying for maintenance of common seniority list, which is contrary to the Buddhist model. Therefore, any other bus in WBC 222 will have a direct bearing. Therefore, Lordship, my prayer is this two writ petition, that is item 24 and 25, may be taken up after disposal of
Possibly that can't be done. Possibly that can't be done because there is a judicial order to take up the matters together. We have no good reason to hold that.
In that case, Lordship, hearing will be considered tomorrow. I am representing the respondent and item number 24.
No, not tomorrow. We'll take it up now because tomorrow division bench is very hard to constitute.
Tomorrow and after, I have fixed a criminal case in Queensland. So I'll be traveling tomorrow. If my argument is over today, then I have already fixed a case in Queensland for one criminal case.
We are returning you your petition. You can just make a photocopy of this page and give it to us with the number on the top. Give a copy to Mrs. Joe also.
Lordship.
Okay. The other two writ petitions have what is the subject matter challenge?
We're challenging we're praying. We're praying to maintain common synergy of armed branch and armed branch from the rank of sub-inspector inspector. What you will see, this is resolution 232 of 2021, the prayer, worship just 32 and 37 is same. Prayer also same. Page 43, prayer. This is repetition 232, 32, 37, same grievance, same leading, prayer also more or less same. Prayer is page 43. No.
Yes, which page is that office memorandum of 9/3/2010?
My lord, 2010.
Is the document available in this
Yes.
232?
Yes.
Show it
Correct.
from 232.
232 is available.
No,
I have
222, sorry, 222
I have
is available there. We'll mark that from here. No,
Page-
222. This order of
Page 36.
OM of 9/3/2010. No, I understand whether it is here. I am asking. If it is here, I'll have to see only one document. It's not there in 222
Page 37, page 37.
or 222.
Yes. Page 37.
7. Many documents.
Well, of which-
It can be there in one petition.
I save my time because then I have to look at
Yes.
maybe one paper book,
Well,
not the others. This right, I heard Mr. A. Zul, learned counsel for the petitioner. Mr. T.V. Jamil, learned.
For R2.5.
Two, 4 and 5.
2.5.
And you're also appearing in this 222? 1 and 3. Mr.
T-Bob.
T-Bob from the government advocate appearing for respondent number 1 and 3. In WPC 222 or 2022. And in addition, in connection with WPC 232 of 2021 and WPC 237 of 2021. Also heard Mr. I'm sorry, I forgot the name.
What is it?
What is Jamil? And then counsel for the private respondents.
Some of the beverage respondents, Lordship. Beverage respondent number 7, 11, 22, 23, 27, 21, 44, 54, and 66.
Okay. My lord, in other rate petition, I'm appearing for respondent 1 to 4.
Okay. Acha. In this other two rate petitions, the government advocate is for 1 to 4. You're also appearing, Mr. Jamil, in that no matter. No, you're not there. Submissions are concluded, order reserved. I'm asking leave, sorry, excuse from the bar, I am forgetting names. So please excuse me for forgetting names.
my lord,
I'm very sorry, but.
no issue. Lord, whether there'll be SB or not, after this. Whether there'll be SB sitting after this. Cost list is there.
No, I don't think we'll be able to.
Why?
Not the entire set, only that list of the parties. Only one page. List of the parties. You said that he is respondent number 7. Only that much.
Now we move.
You can get a photocopy. You can give it tomorrow.
We got it.
You can give it tomorrow.
We understood.
Next week. Next week. Acha, all the other matters which could not be taken up today will be listed before the DB, next available DB.
And SB matters.
Single bench matters.
Single is constituted Lordship after it, but then since there's no
There
time.
should be no time.
Tomorrow?
Can
Those
we
should be.
discuss tomorrow? In the supplementary.
Tomorrow supplementary.
Just tell the court master, we'll adjust it.
Yes.
In whichever case you want it tomorrow, we'll do it. No, it's okay. Just indicate the dates to the court master, we'll pass orders.
Yes.
We'll say that due to positive time, matter could not be taken up today. List on so and so. Just indicate if you want some urgency, we'll take it up tomorrow.